Namaste and greetings. I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्था, Nai Delhi, extend my warmest welcome to you all to IMPRI Web Policy Learning. Today, we are gathered here for the day 4th of LPPYF Law and Public Policy Youth Fellowship, Cohort 3.0. The theme of this cohort is Advancing Justice, Bridging the Gap in Public Policy Enforcement. We welcome you to join us for an immersive journey into impactful policy and action. The chair for the program is Professor Vibhuti Patel ji, visiting distinguished professor, IMPRI. The lead advisor and legal hands-on session will be dealt by Advocate Dr. Shalu Nigam ji, visiting senior fellow IMPRI, advocate, author, and researcher, gender and human rights. Our expert panel for the program includes Mr. Himanshu Shekhar ji, Senior Editor, Political and Current Affairs, New Delhi Television Limited, NDTV India, visiting Senior Fellow, IMPRI. Advocate Lara Jesani ji, Independent Law Practice Professional, Mumbai, Human Rights Activist and members, PUCL, People's Union for Civil Liberties. The conveyors for this course are Dr. Ajay Guruvarth ji, Advocate Selin Thomars ji, Dr. Sibi Mehta ji, and Dr. Arjun Kumar ji. Proceeding further, we welcome everyone to this transformative journey and appreciate your dedication in investing your time, energy, and commitment to gaining a profound understanding of the crucial role and intricate details of policy and action. We have also shared course outline and reading resources in your email for your kind perusal. Before we start today's session, I would like to state the housekeeping announcements. Please join the meeting on time. There will be a question and answer session after each presentation. Share your questions on the question and answer box. The question must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. To begin today's session, I would like to invite our chair, Professor Vibhuti Patel ji, visiting distinguished Professor IMPRI, to give her opening remarks. We welcome you, ma'am, and over to you.
Yeah. Thank you, Ritika, for introducing the course and also explaining the rules of the course. First of all, like now we are on the 4th day and we have had a very interesting journey so far. And I would like to thank conveners, Dr. Arjun Kumar, Dr. Simi Mehta, Dr. Ajay Gudavarti, lead advisor, Dr. Shalu Nigam, and coordinators Vaishali Singh, Priyanka Neki, and Preksha Jalat, and moderator Ritika Pandey, and the esteemed guests of today, Mr. Himanshu Shekhar, Advocate Lara Jesani, and Advocate Shalu Nigam. The brief recap of the previous 3 days, that first we had an inaugural session by Shri Shailesh Gandhi, who talked about the time-bound justice and the socially, and we had a second presentation, equally interesting, by Sandeep Chashraji on socially inclusive justice. Both of them highlighted that whatever is promised in the constitution and in the laws and policies, so many times get delayed or doesn't get realized because of the bureaucratic lethargy, lack of political will, corruption, and no pressure on the authorities demanding their accountability. The only solution is to have a mass-based social movements and pressurizing and demanding accountability and the responsible behavior of the criminal justice system, of the governance structures. So that was in nutshell what we got in the day 1. Second day was marked by presentation by Dr. Vaida Nayanar, who unpacked the concept of democracy and all the theoretical underpinnings, cross-country comparison, how democracy plays out in USA, Switzerland, in the Scandinavian countries, in Canada, and the various routes of arriving at a democratic governance, and whether it is through referendum or through by election or by public debate resulting into electoral processes. But what is important that we found that it is you may have a democratic electoral system, But there too, like whenever you have a majoritarianism, where the minorities' rights are subsumed or they are not respected, then I think we need to also have a security and a more level playing field for those who are minorities, whether they are ethnic minorities, sexual minorities, or religious minorities, and also the gender minorities. No, so that is a very important, and she gives so many examples of the recent times of Algerian revolution or the UN electoral system when Mr. Trump was elected, and what kind of uh, chaos that American civil society experienced, and also UK after Brexit, and the recent developments of the European Union election, where again the right-wing wave is reigning supreme, and there are anxieties about what would be the rights of the minorities and also rights of women. Second, after that, we had a presentation by Professor Sina Paul, who explained to us the grammar of research paper writing, and she covered 10 steps of ideation. What should be your research topic? How to write the abstracts, how to write introduction, in review of reflection, review of literature, how to make critical reflections on whatever you read on the related subject. What should be your area of inquiry? What kind of research methodology, that means the ideological underpinning you will have, and what kind of research techniques or methods you would use? How would you do the data cleaning, data processing? In qualitative research, your words are your data, while in quantitative research, you have your percentages and number. Then the discussion, limitations of your research, what are the future scopes for further probing of the research areas, and also how to do the referencing. Now, third presentation we had was by Dr. Shalu Nigam, who gave us legal hands-on second part, which was the first part was also very interesting on the on the right to food, which she had uh, uh, dealt with in the day two, where she spoke on various approaches to right to food and how the whole journey of how we managed to get the right to food under the Constitution of India because of the pressure which was created by the social movements, and the petition public interest litigation filed by People's Union for Civil Liberties that also culminated into national level debate on food issues, and there were grassroots movements also which were demanding right to food. Her second hands-on, which was on third day, was on access to justice, and she explained the whole processes and the nuances of free legal aid to empower poor and marginalized right from the start, or what was the genesis of Legal Service Authorities Act in 1987, the role of very progressive judges like Justice Bhagwati played, what are the types of legal services which are provided under the Act, who are the eligible categories of citizens who can access the legal aid services, and the free legal aid, how can it what is the financial backing, that means the union government and the state government, what role do they play in providing finances. She also explained the Lok Adalat, which is a forum where disputes and cases pending in court of law or at the pre-litigation stage are settled. And she also said that the nature of cases which are referred to Lok Adalat by basically the cases which are provided where the matter relating to offense not compoundable under law shall not be settled in Lok Adalat, and how to get cases referred to Lok Adalat for settlement, and what should be done with the long pending cases, and how the state legal aid service authority and district legal aid service authorities, they also facilitate the process. And she ended with the details of India Justice Reports 2020, 2019, 2020, 2022, produced by Tata Trust. And she concluded that access to justice and effective functioning of justice system is critical for national development. And also and for that, we need to improve legal infrastructure and also per capita spending in the budget but even the CSR fund should be used for financing legal aid services so that better compensation can be paid to defense lawyers. Thank you very much.
Thank you, ma'am, for walking us through the introduction of this program. Now, I'm delighted to invite Mr. Himanshu Shekhar ji for his session on pillars of democracy, institution, and practice from media lens. Over to you, sir.
Am I audible?
Yeah, yes, sir, you are audible.
Yeah. Okay. Thank you so much. It's a great privilege to get this opportunity to interact with all of you. Thank you, Arjun sir, for always giving me an opportunity to share my thoughts with students, with researchers, and with domain experts. Today, I wish to focus on perhaps the most important pillar of our democracy, which is Parliament of India. And as a parliamentary affairs correspondent for 23 years, I've had the opportunity to actually see how Parliament works from very close quarters for 23 years. I remember when I first went to Parliament, I never imagined that I would ever get to see Indian Parliament. That was in 2001. I was a very young journalist and very fortunate that in the very first year of my career, I got an opportunity to visit Parliament, and not only visit Parliament, but also to report and interview the power elites, representatives of people, and also to see. I would say that it has been a great journey to actually understand how Indian democracy works, because most of the work is being done in Parliament of India, which is a great consensus building institution, whether it is formulation of laws, policies, or building up a national consensus. Parliament, of course, is the most important institutional platform that is available in our democracy. I wish to just focus on a couple of things. One is the formulation of law. In any democracy, I think consensus is the most important issue when it comes to lawmaking, because we need to formulate laws on which there is a larger national consensus, and the majority opinion in parliament is in favor of it. And I wish to share some institutional mechanism that exists in parliament to build up consensus even on most contentious issues. Now, in recent times, the social media has emerged as one of the foremost subject on which there has been a long national debate in terms of how we should regulate it. Now, not only in India, but globally, this has become a big challenge for the global community to actually formulate laws, policies, and regulations to actually regulate the social media content, which actually affects hundreds and millions of people worldwide. There have been questions about safety of women online, safety of children online, and etc. etc. Several issues have actually emerged in recent years. The first effort to make a law in India actually started in 2017 when a high-level committee headed by former ISRO chairman, I think Kasturi Rangan, was set up in 2017. And after the experts committee submitted a report, and which is the normal procedure to formulate law in India, the government of India then invited suggestions from stakeholders on a draft that was prepared on the basis of the expert panel's report. The first draft series of consultations were held with stakeholders. Then the government amended the first rough draft it had prepared, which had been made public. Then finally, a bill was introduced in 2019. And I remember I was in Parliament and there was a lot of protest from opposition MPs that the draft of this bill is not what it should be. Then there was a decision taken to set up a joint committee of Parliament to actually carry forward the deliberations on this very sensitive piece of legislation. And I remember in the joint committee held around 200 meetings in the next 2 years. And a series of interactions were held with stakeholders, Facebook CEO, Google CEO, Twitter CEO, Amazon CEO, anyone you can think of. All these important stakeholders and their representatives and the leadership team were invited to actually give and share their views as to how the social media should be regulated. And by the time, in 2 years' time, that these deliberations were held, the government decided to withdraw the bill in 2022, even after the Joint Committee had submitted a detailed report. And the argument was that in this period of 2, 3 years, the developments and advancements in communication technologies have been such that it has necessitated several new regulations that government wanted to include in the legislation. And then in 2022, another draft was introduced. The earlier draft was called Personal Data Protection Bill. The new one was called Digital Personal Data Protection Bill. And then it was again brought up first in Lok Sabha, then in Raj Sabha, and there was a lengthy debate, lots of protests, and then finally a law was made. Now, this actually gave me an idea of reporting. I've done hundreds of stories on how social media draft regulation was being framed, the questions that arose in this period. And it was actually very rewarding to actually see finally a law being made. But it took almost 6 years for India to put in place a piece of legislation to regulate a platform which is now influencing us every day. And I remember uh, this, of course, has been a very acrimonious subject of debate worldwide. There have been several very contentious debate in Britain, in US, in other developed countries, and they are actually far ahead of us. China, in fact, has even formulated a law on artificial intelligence, which we did not have. But I remember just a month after the Digital Personal Data Protection Law was passed, suddenly lots of fake videos started getting circulated on the web. And then there was a realization that these deep fake videos that were being circulated are far more dangerous for Indian democracy. And there was a realization that, do we need a new law now to regulate deep fake videos? Because the Prime Minister of India said that a video of me dancing and doing a dance in a public program is now being circulated, though I've never ever participated in any such dance program in my life. And then in the recent election, you saw concern about Home Minister Amit Shah's video being doctored videos being circulated. And then the FIRs were lodged. He was seen as speaking about a subject which he never ever spoke, but that video went viral. So there, all these challenges that I've seen Indian democracy face in last few years, through a very calibrated institutional process of consensus building, the laws and regulations have been framed. In fact, as we speak, the government is now in the process of replacing the IT Act with the Digital India Act. Now, IT Act was formulated in 2000. It has been 24 years since the law was put in place. And there is again a greater realization that India needs a new law to replace the IT Act. And the first draft is called Digital India Act. And I'm sure that when it comes to Parliament and it goes for deliberations with stakeholders and interministerial consultations, it is not going to be easy for government to frame a law. But that is the power of Indian democracy, that despite differences, despite contentious debate, once a law is passed in Parliament, everyone accepts it as an acceptable piece of legislation in a democracy. And that is the power of Indian democracy, the process of consensus building. And we have seen the institutions also evolve in last 20, 25 years. And there's a far more greater transparency and far more greater deliberations that we see now in Parliament. And similar was the experience with regard to the GST laws, for instance. As far as elections are concerned, we do know that is another important institutional mechanism that exists in India. And I have had the opportunity to cover all 7 phases of elections. And despite the fact that there were several parties and institutions, they were filing petitions in Supreme Court about EVMs and the fact that how transparent and how credible they were. We saw world's highest ever in human history, the largest election being conducted, and when the results came out, we saw that was respected worldwide. And so that is the power of democracy. That even when we actually have space to question institutions, to question measures and mechanism, we do actually reach a position where we don't actually question the fundamentals of Indian democracy. We do see politics all around. We do see large number of questions being raised. But finally, you see the dust settle down. And after a long, acrimonious debate, we do see the stakeholders of Indian democracy actually accept the decisions that the majority party takes, though at times it becomes a bone of contention, and it has happened in last few years. But largely, the lawmaking process has in fact been very enriched by this political debate, which at times becomes acrimonious. Then the issue of the center-state consultation, for instance, the questions on federalism, we do see states raise questions on laws like GST. But we do also know at the same time that institutions like GST are a broader reflection of the deep principle of federalism that we see all around. And even those political parties who at times used to raise questions when the GST law was first framed, we see in last few years that those questions and those concerns have actually considerably reduced as the process of implementation of GST law actually has moved forward, and it is being now seen as a reformist legislation. So these are some of the points that I thought that I should share with you. A couple of more institutions that exist in Parliament, for instance. One last point on the budget making exercise, for instance. Now, we do see FM present a budget on 1st of Feb. Now, this is an election year, so after the elections, a full-fledged budget now will be presented in the third week of July. And I wish to just inform you that if you just look at the process through which the budgetary proposals are approved, that will also give us an idea of the consensus building platforms that exist to even approve a proposal like a budget, for instance, which is the most important financial document of Government of India. And once the FM presents the budget in Lok Sabha, we do know that after the presentation of the budget, it is sent to different standing committees of Parliament. As you know, there are different standing committees that are based on different ministries, like Standing Committee on Finance, Standing Committee on Commerce, Standing Committee on Industry, Standing Committee on Law and Labor Welfare, etc., etc. There are, I think, 18 standing committees, and the budgetary proposals for each ministry is then sent to all these standing committees, which now have representatives from all political parties. And once the budget is presented and it is being sent to the standing committee, the process of vetting the budgetary proposals is then taken up ministry-wise. And all important political parties have their representative MPs who are member of the standing committee, and they do the minutest of calculations and examination of the budgetary proposals. And it's only when the standing committees submit their reports on the budgetary proposals for different ministries that it is again taken up for final debate, and the finance bill is then taken up for final approval in Parliament in both Lok Sabha and Raj Sabha. So all these institutional measures that I've made, whether it is budget making process, law making process, or building up consensus on the most important and contentious issues of national interest, we have seen acrimonious debate in Parliament. But despite that, this is also the strength of the Indian democracy, that even those parties who disagree with what the government is planning, they have the space to express their views, and we have learned actually to accept the differences that characterize us, and that has been the strength of the Indian democracy. And all these institutional mechanism and measures that I've mentioned, whether it is Indian Parliament or the process of election, conduct of elections, or the budget making process, these are the pillars of Indian democracy, which we have seen become stronger. And the principle of consensus building has always been part of this exercise, though at times there have been also criticism in terms of how far the views of people who hold different views are actually accounted for. But then democracy runs on the principle of majority, and there is a process through which laws can be passed. And we have seen that process of consensus building from close quarters, but there's a lot of reform also that is needed. There are several legislations that needs to be continuously reformed. One, of course, is the Disaster Management Act, for instance. We know that Disaster Management Act was formulated in 2005, but the intensity, the frequency, the scale of disaster incidents have risen considerably in last 19 years. And lots of voices have been raised that these legislations needs to be reformed to actually empower people to put in place more viable disaster mitigation strategies involving communities to combat climate change, for instance. Now, the weather that we have seen this year, the winters were very harsh and followed by extremely hot summer. At one time, I remember reporting, and I could not believe what I was saying, the temperature had actually gone up to 52.9 degrees Celsius in Mungeshpur. Then later it was denied. It became the topmost story across the world that India is now reporting 52.9. But subsequently, government said that these are not official figures, but overall also the temperatures have been far above normal, and number of heat wave days also has been alarmingly higher. So all these challenges that we see on the ground now, in any functional and vibrant democracy, it's very important that we formulate laws, reform laws, amend laws to actually meet and combat these challenges. And I think government has to be far more sensitive when it comes to dealing with issues like climate change or pollution, for instance. And I covered all 7 phases of elections, and I was still searching that why climate change or abnormal changes in weather or pollution, why they did not become a political issue or a issue in the elections, which is very unfortunate because these are issues which affects us every day and we suffer from it every day. But in terms of a more responsive policy response or a legal response that one would expect, though there are a number of frequency of debates in parliament on climate change has actually increased in last few years. But I think a far more responsive and a sensitive institutional response is required in a democracy to actually help people combat all these challenges, which affects not only stakeholders but common people on the street. Now, many states have even reported heat wave related deaths, for instance. So these are all issues of concern, and I think in any democracy, these kind of day-to-day challenges that people face and the larger challenges that it poses to the health of citizens, to children, to senior citizens, for instance. I think media has also increased its coverage, but I think a lot more coverage is needed. And now we are heading into a monsoon where if the abnormal weather pattern continues, we've already seen devastating floods in Northeast. And now when the monsoon has covered all or the entire country today, that's the news I can share. And responsive and informed and sensitive policy decisions actually to help people combat all these challenges. So these are my primary thoughts, ma'am. If there are questions, I would be very happy to share my answers.
Thank you, sir, for providing such a comprehensive and enlightening session. Now, we invite Professor Vibhuti Patel ji for her remarks.
Yeah. Thank you, Mr. Himanshu. Shekhar, you gave us such a good idea of how does the parliamentary debates are captured by journalists. I want to ask you that personally, how do you do the reporting when very volatile issues are discussed, and have you faced pressure from different political groups or vested interests while doing the political reporting? And when there are extremely acrimonious debates are there, how do you maintain your journalistic ethics by projecting all sides of the thinking, the views?
Thank you for asking this most difficult question. I know we face these challenges almost every day, ma'am. If you just look at the nature of national politics and the kind of debate we see in Parliament now on the President's address, the motion of thanks to President's address. You see, my entire last 23 years of covering Parliament has actually given me the experience to manage the contradictions. Now, that essentially means that you try and balance all sides of views. And, there are some statements which are made during acrimonious debate which are expunged by the chair itself. Now, that is also something that is not coming in public domain, but every day we get messages in our WhatsApp group, on email, that Rajya Sabha chairman or Lok Sabha speaker has actually expunged certain unparliamentary remarks that were made in parliament. So there are parliamentary procedures. There is a code of conduct for MPs. And if any MP or a political party violates that code of conduct, then we have seen that large number of suspensions have also happened. We have seen people go into the well despite suggestions and advices from the chair. But unfortunately, in recent years, such instances were more. But when it comes to reporting, you see, our primary objective is to report facts that we see on the ground. There is nothing else that I'm guided by except the facts, the primary facts. Now, primary facts are very simple. If you remain objective and you try and reflect the views of both the ruling treasury benches and the opposition benches, it becomes very easy for you to do balanced report and try not to, mm, be unfair in any possible way. And in television, especially, the challenge is when you're doing live broadcast that you need a lot of experience actually to do balanced reporting, because then you don't have a text in front of you. And so you have to do impromptu lives at times. You don't get even a minute at times to do live broadcasts. So I think it's just got imbibed in my thinking that when I'm talking about a subject, I know exactly where to draw the line, what I will be speaking, what I should not speak. And I think that has been the guiding principle, that you're driven by facts. It's the data journalism that I do, journalism which has a very strong empirical foundation. And so I speak what has happened. So it's like narrating what I see on the road, for instance. So in that sense, you don't get driven by a particular ideological bias or any other kind. So as far as pressures are concerned, no, I think it has never ever happened. And that's one of the strengths of the democracy. In the past 23 years, I can say that no one has ever told me that if I'm doing live, this is how that has never happened. But I can say in all seriousness. I mean, I've worked since 2001. Several prime ministers I've covered in last 20 years, and it has been the culture. When it comes to reporters are absolutely free to do reporting, but I think the challenge also we face at times is that what constitutes balanced, for instance. Even that at times can become very contentious. So we do try and be fair and objective when we report. And if I think that any researcher or a reporter or a journalist, if they stick to facts and data that they come across, I think they will always be respected.
Thank you.
Participants can now ask their questions. Participants can either raise their hand or type their queries in the question and answer box.
Any answer? Just one thing, like you say that, it's your own, the subjective kind of editing, but sometimes you're like, as a person, since you have been working in this field for so long, you may have your own personal views about any subject, and that may really, comes in between. So even if you say that, okay, the glass is half or glass is full, so those kind of things could also come in. Another point is that when you talk about the law on digital protection, now the new techniques are developing each and every day. There's artificial intelligence, there's chat GPT, and so many other things are coming, which requires intervention in terms of not only the technological law, but also say the amendments in the copyright law. So if chat GPT is copying my data, so I have to ensure that my data should be protected. So those kind of changes require sometimes you have to act immediately, but the way the democratic system works, it really takes a long time. So with your long experience, what will you suggest should be done in this kind of situations?
Yeah, important question, ma'am. Your first observation, I respect that. But only you can tell me how fair I am. I, of course, open to all criticism, and there are people who have met in the field. They say, I don't like what you did on that day. I said, I respect your views, sir. Or somebody from the other side would say, no, you did great journalism. I said, thank you very much. So a journalist has to be, ready, because we do television reporting. If you do for 23 years on India's biggest national networks, then even in Singapore, when I was once traveling, 6 people came, they said, I want to take a selfie from you. Initially, I was very worried why they are staring at me. I thought that they have come to loot me in the metro. And then they said, oh, you are Himanshu Shekhar from NDTV, and we need to take a photograph because I watch NDTV every day. So it's a job which is very transparent, and I move around in the public, and you meet critics. There are people who say we don't watch your channel. There are people whom you meet, you say we love your channel. So I said, sir, I respect your views. So it's been like that. So, but I think a fair assessment only can be done by you and other scholars who can objectively assess my work. But I have my job is to be as objective and fair as possible. On the second important question, you're absolutely right. As I mentioned, China is the only country which has made a law on artificial intelligence. Even in the world's most developed economies, such laws are still in the process of being made. Now, on the deepfake videos, when the first concern was expressed by Prime Minister of India, there were two meetings were held. One by Ashwini Vaishnav, who at that time was Communications and IT Minister, and the other by Rajiv Chandrasekhar, who was the Minister of State for IT and Electronics. Ashwini Vaishnav said that we have three options. One is to make a law to regulate AI and deepfake videos. Second is to amend the existing law. And third is to put in place new set of regulations, because regulations are easier for the government since you need to hold consultation with stakeholders and release the regulations. But when it comes to law, you're absolutely right. It takes time. I mean, as I said, 2017 experts panel report to India getting a digital personal data protection act in 2023. It took 6 years to do that. So that, of course, will take time. But I think the government is working on all three options, making whether it should be there should be a new law or the existing law needs to be amended. And third is they put in place new set of regulations to regulate AI by the time you get a full-fledged law that they did in case of social. The other view is that Rajiv Chandrasekhar shared a note with us which said that in the existing IT Amendment Act and also the IT rules, there are enough provisions to deal with cases of deepfake and AI, misuse of AI. So by the time India has a law or a new set of regulation, the existing IT amended rules of 2021, I think, gives enough powers to the government agencies to crack down on the misuse of AI. And if you just look at the Amit Shah case and the speed with which action was initiated, that clearly showed that India at the moment has a legal framework in place. And so in the high profile cases, we have seen very swift action, whether it is Amit Shah or I think Smriti Mandana is the heroine, Bollywood heroine, when her deepfake video was circulated on the web. So we have seen film actresses, in case of senior ministers or even prime minister, very swift action has been initiated. But I think you're absolutely right. And India needs a full-fledged law, and we have to start moving very fast in that direction. But a Digital India Act is in the process of being put in place. Yeah, I can say that, to replace the IT Act.
Yes, sir.
Nikhil ji raising his hand. You may speak, Nikhil ji.
Uh, uh, Good evening, everyone. Good evening, Himanshu, sir. So I wanted to understand that what is the role of media and the journalists, media organizations and the journalists in the detection and the reporting of the deepfakes? How effectively it happens? For example, whenever a video surfaces, like you mentioned about Prime Minister Modi or our Home Minister Amit Shah's video. So how effectively and instantly the media gets into work when they find such videos online and they try to curb it down, or what is the responsibility of media in such scenario? Or in second question, I wanted to ask, are there any international models that as a policymaker we should, as in the policymakers of India should consider as an example from political scenario of foreign countries where such an incident has happened and how they have been tackled?
Very, very important. I think, I think I can say about NDTV that the moment a deep fake controversy has arisen, we have invariably done a story. Not only a story, but we have done shows where we invited the IT experts, IT law experts, cyber law experts, and other experts to actually brainstorm on whether what needs to be done in this case, and whether it is the Bollywood actress Smriti Mandana's case or Amit Shah's case or Prime Minister Modi himself expressing concern about his own deepfake. If you just look at the Google and just see the responses, the very wide, extensive coverage has been done. But I think the point that you're making is also right, that these cases get highlighted when a celebrity is involved. But I remember Shashi Tharoor, who was the chairman of Parliamentary Standing Committee on IT and Communication. He once told us that why he selected the subject of safety of women online, safety of children online, was because of large number of complaints that he had received in his constituency from different segments of the society, especially women, who always would complain that their photos are, you know, are being misused on social media platform, their accounts are being hacked, and so this has been a concern for the media, but I think media needs to be a little far more sensitive to this issue than what it has been. At the moment, whenever a big celebrity or a senior minister, if a complaint comes, then it becomes a national story. When a normal girl, when she becomes a victim of online crime, those cases, in relative terms, should also be given more space in national media. As far as references are concerned, as I said, the IT expert, uh, IT law expert, once told me that China is the only country which has a law on artificial intelligence. But the other developed countries are in the process of making legislation. And I think in terms of references, I've read briefly the US laws and also UK laws. They are comprehensive. And I think when we work on putting place a new Digital India Act to replace the 24-year-old IT Act of 2000, I think we should also study these laws and legislations and regulations that are being put in place in European Union, UK, US, because this is a big global issue, and I'm sure that social media needs no boundaries. And one of the things that we learned in the first meeting of the Parliamentary Joint Committee was that all the data of hundreds and millions of Indians on social media platforms, most of it is saved in US server, which is regulated by US laws. So I think this was also a big challenge that most of these big tech companies have their headquarters in US, and most of the data that they have collected, the personal data of citizens in India, and I remember there are around 398 million Indians on Facebook, which is around 40 crore. So in a population of 145 crore, this essentially means that out of every 4%, at least one has a footprint on Facebook alone. Google, again, the numbers would be far more higher. So, of course, this is a area in which I think the global community needs to cooperate more. Nations must learn with each other in terms of putting in place a very concerted collective strategy to actually deal with this menace, because regulating social media, as the previous speaker was mentioning, will be a big challenge. By the time you put in place the Digital Personal Data Protection Act, then the problem of deepfake comes, which is not even mentioned in that act. So the advancements in communication technologies are moving at such a fierce pace that in every couple of years, I think the governments will have to go back and see whether the legislative framework they have put in place are viable enough to deal with these challenges. I hope this answers your question.
Yes, sir. Thank you so much. Thank you for giving such good examples and elaborately still explaining. Thank you so much.
Yeah. Anyone else who would like to ask some questions to sir? Okay. Thank you, sir. We at IMPRI hope you continue to collaborate with us in the future as well. Moving on
Thank
to
you so
our
much.
next session, I'm honored to invite Advocate Lara Jesani for her session on climate change and environmental justice, current policy changes. Over to you, ma'am.
Hi, are you able to see me and hear me?
Yes, ma'am.
Okay. I wanted to use a presentation. Is that possible? Can you give me some sharing rights?
Yes, it's given already. Please try.
Are you all able to see this?
Yes, perfect.
Okay. So thank you very much to IMPRI and to all the presenters for inviting me here, for all those behind the organizing of this program and this course that you all have been holding, I think, for quite some time on public policy. I was listening to the earlier session and it was quite interesting to hear from Himanshu ji on the lawmaking efforts on data protection and several other debates that happened, even the questions. And I am going to talk about something totally different, a lot more critical, I guess, because of the subject that I have been entrusted with. I'm a lawyer. I practice in Bombay High Court and in the National Green Tribunal. I take up environmental cases as well as constitutional cases. I'm also part of People's Union for Civil Liberties, which has been part of policy debates and also litigation advocacy and other forms of advocacy in order to engage with the lawmaking process. And I am currently the National Organizing Secretary. The issues that I'm going to look at today is, I think, something that something all of us are facing, debating, and conversing about a lot more in the last few years, which is on climate change and of course looking into environmental justice and what are the policy challenges that we see today. I must also say, something very important at this stage, that as far as, policy debate or policy or intervention in the lawmaking process on environment is concerned, there has been, very little transparency or very little engagement or public participation that has taken place. And so what we will probably, be looking at more during this session is the, critical areas of where law is failing, or where there is a need for intervention, or there is a need to do a lot more as citizens, as civil society, and also as those who are engaged either as advocates or as stakeholders in this process. So that's what I will try to do here, and of course I look forward to any kind of conversations and discussions that it brings up. We also have, a lot of people from IMPRI who have been, including Arjun Kumar ji, who have been, looking at environmental policy issues. So I also invite them to join in and, contribute if I miss out on anything. There's very limited time, so I won't be looking at all the issues. The presentation is quite big, but I'm going to speed through some of the issues. First is, understanding what is climate change to begin with. Now, a lot of us know what climate change is, in terms of, conceptually understanding it, or understanding it in a very broad way, as, there is a weather change. We fall sick, there's a weather change, I fell sick. My hair's falling, there's a weather change, the water is bad, my hair's falling. So all of these, we know that the climate is changing. We know that there is, a shift that is taking place in terms of the weather. But what is exactly climate change and what is causing it? I think is one of the, it's the main issue that we're going to look at. First is what causes climate change? Now, climate change, of course, is, generally, if we have to use, a very simple language to understand what climate change is, currently climate change is what we call global warming. Due to the indiscriminate use of fossil fuels, the destructive development model and the various activities around it, the pollution that has increased, the kind of environmental destruction that has taken place, we have seen an increase in carbon emissions. Also, deforestation leads to carbon emissions because of the release of carbon dioxide due to deforestation activities, what we call as forest diversion activities under law. So deforestation is seen as one of the biggest causes of carbon emissions, and also the increase in greenhouse gas emissions, which basically trap heat in the atmosphere And this effect is called as the greenhouse effect, thereby increasing the atmospheric temperature, which is what we call as global warming. So climate change in a nutshell right now that we are experiencing is global warming. And global warming is taking place because of the increase in carbon emissions driven by destructive development activities, pollution driven by, the use of fossil fuels, that is the non-renewable sources of energy, and also because of a huge amount of deforestation that has taken place and environmental destruction that has taken place in order to do extractive mining, in order to put up power industries, in order to, exploit, the forest land, and in order to, basically further a development agenda which is not sustainable. Now, what has this led to? What has climate change led to? It has led to extreme climate events. We are seeing them, whether there are floods, there are landslides, there are, forest fires that are taking place. There are extreme, temperature conditions. Right now, we have been experiencing a heat wave, even in a city like Bombay, which used to, dissipate the heat because it's a coastal city and because the sea has been quite kind to us in taking away the impact of increasing heat and the humid temperature. Yet we have seen over here the worst humid heat waves that have taken place this summer. And there's very little, in fact, understanding on humid heat waves as well. It's a developing area. And this has also caused an increase in, health issues. It has caused an increase in, it's caused an increase in heat strokes, in all kinds of health complications and comorbidities. We also have, apart from these extreme climate events, what we call as the slow onset events. Now, the slow onset events is a steadily increasing temperature. You all must have all heard of the Paris Agreement, which had, which had an objective to ensure that, the temperature would not increase the turn of the century beyond 1.5 degrees. This was in order to prevent the, cumulative impact or the slow impact of global warming that we are facing, which will lead to ultimate destruction of many areas of the planet. Second is desertification, loss of biodiversity, the land and forest degradation. We are also seeing glacial retreats. You must have heard of the glacial retreat, which is taking place in Ladakh. The Himalayan glaciers are retreating. It's also leading to, flood events. So these glacial retreats will also, lead to huge capacity extreme climate events and high impact extreme climate events and disasters. We also have a very big problem of sea level rise. You all must have heard, even in coastal cities of India, Bombay, you have cities like Kolkata, Chennai, which are looked at as hotspots today because of the increasing sea level rise. And salinization. The salinization also increases because of the climate change impact. Now, these are no longer what we call as natural disasters. We always call them natural disasters, but they're actually not natural disasters. These are all human-induced disasters. There are certain amounts of there has been climate change that has taken place because of which civilizational changes have taken place. But what we are facing today is an accelerated climate change, and which cannot be which can very much be controlled, but which cannot right now, with the way the development agenda is, the destructive development that is going on, we will not be able to surmount. So this is a human-induced disaster. It is no longer a natural disaster. Now, coming to the situation worldwide, what has happened now? 2023 was declared the hottest year by NOAA, National Centers for Environmental Information. It is the hottest ever recorded year. The record started in the 1800s, and it has, and this is the most alarming factor We also had the UN chief, we also had the UNEP and several organizations of the United Nations working on environment issue very critical statements in 2023 and again at the start of 2024 because of the accelerated way in which global warming has taken place. You also had the State of Global Climate Report, which basically said that 2023 has broken the records for ocean heat, sea level rise, Antarctica sea ice loss, which is the melting that is taking place in Antarctica, and the glacial retreat. Now coming to India, 75% of Indian districts are extreme climate hotspots, and this is unprecedented. You see, India was the last as far as its environmental performance was concerned. It was 180 rank out of 180 countries under the 2022 EPI, which was the last EPI. Now, the latest EPI has come just a few weeks back, and we have ranked 176. The reason why this is, we are also at the end is not just because of of course, the massive pollution and the massive, carbon emissions and the massive, deregulation that we have done, but also because we are facing the impact of climate change. We are not just causing it, but we are facing the impact of climate change at the highest level, and our health indicators and environmental factors leading to deteriorating health is the worst. In 2019 Lancet report, if we see, shows that 12.5% of deaths have taken place in India, somewhere linked to environmental factors. Also, India ranks 7th in the world for climate vulnerability as per the 2021 Global Climate Risk. The reason why I'm saying all of this is to understand why policy intervention and policy implementation is extremely important, and it will be a very, very critical stage as far as India is concerned. Now, in 2024, already we have seen the worst heat waves. Rajasthan and Haryana surpassed 50 degrees on multiple days between 1st March to 18 June. 110 people, according to the government released data, have been killed because of heat wave, and 40,000 people have suffered heat strokes. This was earlier in the month, the numbers have increased. There's been a 5-fold increase in forest fires in Uttarakhand. 11 people have lost their lives, but imagine there are 5 times more forest fires. Uttarakhand has always had forest fires, but it has exponentially increased this time. We also had Cyclone Remal that took place in northeastern states. I was, in fact, in one of the northeastern states when Cyclone Remal happened, and we had to be rescued by the Disaster Management Authority. 58 people have lost their lives in this. Lot of land, thousands of houses were destroyed. People have been displaced. They're still living in relief camps, and they have lost cultivable land and crops. Also, what we're seeing ongoing right now are the Assam floods. Also, Sikkim is facing, very torrential rains. A lot of parts, in fact, have started, facing torrential rains. This has led to, more than 4 lakh being affected in Assam already. Now, the biggest critical thing over here is that climate change impact is become a really big issue because it impacts the GDP of the state. It pulls down the people as well as the state economically and financially. So looking at climate change as a very critical issue, as a very critical policy issue, has become extremely important. Now, there's an urgent action needed to stop climate change, which of course means that we need a complete change in the development agenda that prioritizes the rights of the people, the environment, and sustainability over private interests and commercial exploitation. We need to stop unsustainable and destructive development, put in place a very strong regulatory framework in order to restrict and prohibit all destructive activities. And we also need urgently a moratorium on deforestation and forest diversion. Development that requires forest diversion cannot be allowed to take place, and that we have to look at alternative solutions. We cannot lose our natural forest cover and try to build artificial forests because they are not going to be good carbon sinks. In fact, this entire building process of artificial forests has shown huge amount of defeat. There has been very little success. We also need a just transition. And when I say just transition, it means a transition that takes into account people's interests, and especially the interests of the indigenous community, the Adivasis in India, when we look at a transfer from green to renewable, non-renewable to green and renewable energy. And we also need to establish, very strong mechanisms to ensure preventive justice and restorative justice and all remedies. Now, what is the basic requirement for environmental justice? Access to information is one of the most important principles of environmental justice. Without having information, people cannot fight for their rights. And most of the time, in order to fight any destructive activity or a project, you require project documents, you require, to know what is the impact of the project, what are the site studies that have been done, what are the various, mitigation studies that have been done. So you need information about that project. What is the feasibility of the project? Should the project take place only over here? Should it take place only in an environmentally fragile place? Can it take place in some other place? So all of these things one needs to know. And for that, people need to have access to information. We have access to information through the Right to Information Act 2005. And when the Right to Information Act 2005 came, it in fact enabled environmental litigation immensely. In fact, this was the time, between 2013, 2016, 17, was when I got into environmental litigation quite a lot. That was some of the formative years of my environmental work. And at that time, most of the cases that I was fighting was based on documents that were received through the RTI process. Second, a very important principle is participation in decision-making process. Now, you have the state and you have the corporate interests or private interests who are, looking at coming up with projects. Now, if they are allowed to just go ahead and look into project, they will look at their profit or they will look at establishing their infrastructure, their development as per their agenda. But in a participative democracy, and especially in order to ensure environmental justice, it is extremely important that there is public participation in the decision-making process. So if a project or an activity affects a particular community or affects the environment in which that particular community lives or their natural habitat, then they should have a say in whether that project should happen or not. They should have a say in engaging with the decision makers. So this is called as free prior informed consent, or FPIC. And in our law, we also, in the environmental laws, we have what is known as the public consultation process. In the EIA, that is the Environment Impact Assessment process, is an important step. So this FPIC we see by way of, for instance, in FRA and PESA, you have a process of getting Gram Sabha consent. So this is a process of FPIC. Of course, we need a very stronger, recognition of FPIC, that is the right of, communities to engage in the process and engage in the decision making. But this as well as the rights of Adivasis or indigenous persons is very little recognized in our country. We do have laws which provide for some of these rights, but they have been diluted, and we'll come to that. Third is the social and environmental impact assessment. This comes under the EIA law as well as the land laws. We have in the land laws also a social impact assessment chapter. The fourth is access to justice, which means preventive justice, because we have, principles such as the precautionary principle, which talk about, you can't wait for the damage to take place. You have to stop the damage from happening. That is a preventive, a principle of justice. You have remedial measures and you have compensatory measures to remedy the wrong, and compensatory measures, which again looks at absolute strict liability, polluter pays principle, and all of these principles, which I will not have so much time to get into in depth because I have very limited time. But these are extremely important principles of environmental justice. And fifth and the last. Now, when I say that laws are being diluted to take away public consultation process, how many projects are taking place around you? How many of them have been opened up for public consultation? Has your view been taken? No. So when the public consultation process is not there, you don't get copies of documents because RTI now is not producing the same impact that it used to earlier prior to 2017. If you're not able to go to courts, NGT was shut down for a couple of years. Again, people were not able to go to court because the zonal benches were shut down for a good 3.5 years. If you don't get any of the steps above, then what choice does the public have? What choice do we have as citizens? That is to use our constitutional rights under Article 19, which is of freedom of speech and expression, which is of freedom of association and assembly, which is our right to dissent and right to protest, and to put our views to the government that no, this project is harmful, it is harming the environment, and hence you must scrap it. And that is our right, which is a constitutionally recognized right. So defending our democratic spaces and protecting environmental defenders who actually do this job becomes extremely important. Now, the environmental governance structure in India is, first and foremost, initially when the 1949 Constitution was drafted, it did not have a fundamental right to the environment or right to the environment recognized. But the right to life was seen as, comprising of a right to live with dignity by the Supreme Court in several judgments. And it was held that right to a healthy environment is an integral part of Article 21. I just want to break for 1 second and check how much time will I have to continue the presentation. Can someone of the organizers just tell me a time, please?
Yes, please take your time.
Okay. Now, so some of the most important laws that came in, were actually took place because our world was recovering from wars, and post these wars, they went foraged into development. Industrial development started happening, destroying the environment. There was absolutely no regard for the environment in any of the development plans at that time, because poverty elimination, bringing the countries back to speed after the destruction that was caused during the world wars was the main objective. So their only goal was development, and only goal was restoring the economy. And so in this spree, what happened is huge amount of environmental destruction took place, and the impact of this in terms of pollution, in terms of emissions that took place started becoming a matter of concern. This was taken up for the first time in a very big way for the first time, but in the United Nations Conference on the Human Environment, which is known as the Stockholm Conference, that took place in 1972. India's environmental regime also started through many of these discussions. The Wildlife Protection Act came in 1972 in India. We had the Water Act, Forest Conservation Act, Air Act, and Environment Protection Act of 1986, which were the fundamental, laws that came at that point of time. Now, following this, of course, there are also colonial laws and all. I'm not getting into them. These are some very important laws, so I'm going to concentrate on these laws. In 1976, an amendment was brought to the Indian Constitution. Article 48A was inserted as a directive principle of state policy, which created an obligation on the part of the state to protect and improve the environment and safeguard the forests and wildlife of the country. Of course, what should have ordinarily happened and what should have, what we required was a recognition of a fundamental right to a healthy environment, which did not come and which has still not come. But like I said, the Supreme Court has held it to be a part of Article 21. But this is the lacuna in our constitution. We also had Article 51AG, which was brought in as a fundamental duty of every citizen to protect and improve the environment. After this, in 1992, a very important conference was held. It is known as the Earth Summit. And in this, a declaration was filed, which is known as the Rio Declaration. Now, this is a very important document, and I would suggest you all, go online, even if you all don't look at environmental policy, later on in life. I think it's very important for us to know this even as citizens, because all of these documents are available on the UN website. You can go to the UNHR, HCR website, and you will find all of these documents over there. The Rio Declaration put in place a lot of important principles. For instance, the principle of environment impact assessment, the whole precautionary principle, polluter pays principle, some of those, which had started coming up in conversations post in 1972, were all made a part of the Rio Declaration. You also had a Kyoto principle, which, was brought in order to strengthen this. But a very important thing that also happened at this time was the United Nations Framework Convention on Climate Change was ratified by 197 countries of the world. Now, why did all this happen? And I think over here, you can actually, you might be able to reference this. When we were in school, I don't know if all of you all had a subject. I was in state board, so I had this subject of environmental science, EVS, we used to call it. And in this EVS subject, when we were in school, we heard a lot about ozone layer depletion. This ozone layer depletion was a very big issue that had come up at that point of time. And in order to stop ozone layer, in order to stop this and in order to address this ozone layer depletion, a lot of efforts were made, a lot of processes that were put in place in order to hold the states accountable, and also to ensure that states come up with their own domestic or regulatory framework by which they can ensure that the emissions decrease, the greenhouse gas emissions decrease, and this became the crux of a lot of the laws that came after this. Now, in 1996, we got a very important act called the PESA, which recognized the rights of scheduled areas, and especially the forest dwelling communities, their own right to their autonomy and to make their own basic decisions, to govern, to self-govern. This is a very important part of environmental justice. In fact, we have a UN convention on indigenous rights and indigenous persons. India has not gotten on board, and that's been a really big setback for the indigenous communities living in India. One of the reasons also why the indigenous communities are the most attacked community, they're the most targeted by the state, because each time they oppose destruction of the forest, they face the wrath of the state. But these laws, if we look at internationally, they are well recognized and they are there in many of the countries. So this PESA, was a very important step that happened in 1996. In 2002, we got the Biodiversity Act, again, a very important act. I will not be able to go into the details of all of these acts, but these are acts that you all can also look up, which actually looked at, protecting traditional knowledge or indigenous knowledge, which is attached to biodiversity. Now, this act of Biodiversity Act last year has been diluted, and it actually takes away the right that indigenous communities have to their own traditional knowledge, and allows for commercial exploitation of traditional knowledge, which has again become a big problem. PESA also, in many ways, has been diluted or bypassed in trying to allow for forest diversion by allowing for in-principle approvals to take place without Gram Sabha consent, and several other dilutions that have happened. Then you had in 2005 the RTI, which I said is an extremely important tool in environmental justice, because it provides us as a first step to remedy, to approach the courts, to do litigations, to write petitions, because if we have the information, then we can actually exercise our rights and intervene in the processes. Then you have the FRA, which is the Forest Rights Act, which came in 2006. Again, an act which recognized the rights of forest dwelling communities, and which provided for various mechanisms for protection of their rights at the time of any project or activity. Then you had in 2006 the Environment Impact Assessment notification. This came. It superseded the law in 1994, which was the first EIA law that came after the Earth Summit, which happened in 1992. Now, this required for prior environmental clearance by any project or activity. Okay, if they had to go ahead with any project or activity, they needed to take prior environmental clearance. And this environmental clearance could only be granted after conducting what is known as the Environment Impact Assessment. Now, what is an Environment Impact Assessment? We will get to. Then you have the National Green Tribunal Act, which came in 2010, which set up green courts. And these are present across India. We have 5 courts. We have the principal bench and 4 zonal benches, which is the Western, Southern, Central, and Eastern bench. And these benches which are there, they basically look at environmental disputes in that area. The principal bench is located in Delhi. You also have the Coastal Regulation Zone notification, which came in 2011. It has been replaced now by the 2019 Coastal Regulation Zone notification, which similarly, like the EIA notification, required for clearance, called as a CRZ clearance if there are any activities which come up on the coast or which come up on any of the areas which are provided under Coastal Regulation Zone Act as protected areas. Then you had the Land Acquisition Act, which came in 2013, okay, which governed acquisition of land. And most of the time, these acquisition of land takes place for projects, whether they are public projects or whether they are private projects in partnership with the government or any other projects. The land acquisition is governed by this law, which was brought in 2013. Earlier, the Land Acquisition Act of 1894 did not provide for market rate compensation, which was actually brought in the Land Acquisition Act. There were many things that were needed, which the law could have been much stronger, but of course, it was a very important law to come in 2013 because the earlier act used to just take away the rights of the communities altogether. So some of the rights were restored by way of this law. Now, this is where all the positive laws, in a way, started getting altered. And after that, we have suffered huge setbacks as far as environmental policy is concerned, in my view. In 2016, a law came, the Compensatory Afforestation Fund Act, which provided for setting up a fund for compensatory afforestation when there are deforestation activities. Now, what was being looked at that point of time, or what was being hoped, because we were already suffering climate change impacts and going down terribly on the environment, performance. But what was being hoped for is better regulation in order to ensure that forests are not diverted. But all these kinds of laws came in order to monetize forests or incentivize the destruction of forests. So you destroy forests, just put money in a fund. You destroy forests, okay, and do some compensatory afforestation somewhere, whether the compensatory plants or trees or whatever you plant survive or they don't survive. Right? So all these nominal activities for actually destroying centuries and the old forests, which are the natural forests. Now, India ratified the Paris Agreement in 2015. That's a very important agreement that came in, and India became very important to this agreement because US refused, China refused. So India became like one of the, important players for the Paris Agreement. Now, under this agreement, an agreement was made to limit global temperature increase well below 2 degrees, but preferably to 1.5 degrees. So we don't have to go beyond 1.5 degrees at the turn of the century. Another very important thing that came was the Sustainable Development Goals of 2015, where SDG 13. So earlier there was, before the Sustainable Development Goals of 2015, then this is like, these are goals that go on for 15 years. They are goals that are international, globally agreed goals, which go on for 15 years at a time. Earlier, the goals were what we known as the Millennium Development Goals. And that had like economic growth at the center of it. So it was what was seen is that by not putting sustainable development at the center of it, we had destroyed the planet almost. So they brought 2015 Sustainable Development Goals. The reason I'm talking about these laws is that these laws, on the face of it, looked like the world is waking up to climate action. But these laws itself were used in order to, monitor, to come up with nominal greenwashing exercises so that one could increase the destruction of the environment. And this has become a really central point. And I'm making this, this statement in a very responsible way. Because if we are looking at climate action, that can only happen through real policy implementation, through putting in policy and regulation to protect the environment. But what we have seen from this period when these laws are coming in for the last 10 years is that the policy has only been weakened. Implementation has only listened, right? So how can we actually protect the environment when there is no law to protect it? So that is the critical question that I hope to leave you all with. Now, also what happened is in the name of this corporate social responsibility, a lot of greenwashing exercises have been brought in. There was also this attempt that was made to bring in the concept of corporate environmental responsibility. These are a little more complex things which come under the corporate laws. So I will, leave you all with this. But again, there was a lot of confusion that was created and a lot of inways that were allowed to the corporates to not put in, for instance, mitigation plans, not do studies, not to take care of the communities that are being affected, what we call as the project affected communities, not to secure the project affected communities, not to secure the environment of the area, if they can do all these nominal CSR activities or things under CER, which are tax benefiting or which are, which are mandatorily required under their CSR allowances. So what should have been a part of the project cost, like repairing the environment that you damage or not damaging the environment, and so taking 100 steps by putting in the best infrastructure, by having the best waste management, by having the best, STPs and all of that. You don't do any of that. Instead of ensuring that your project or activity is not polluting, instead you do all these voluntary activities, right? And use them for PR or, for advertising. So this is the manner in which the whole strength of the law was taken away. And these kind of greenwashing exercises started taking place. Now, what has actually happened? I said that some very important, the 5 principles that we have, which are very important, principles of environmental justice. The first principle of them was that we need to have access to information. Without the access to information, we cannot fight for our rights. If we don't have the information, especially communities living in, forest areas, living in coastal communities, which are the most affected by, destructive development, they need the information also, in a readable format in their local languages, in regional languages. They also do not have or are not equipped with information on law and all of these things. So access to this information becomes extremely important for them to access remedy. Now, instead, what happened is there was attempt first after the 10 years back when the government changed. There was an attempt first to dilute the RTI law in order to restrict information. Now, that attempt was not successful. There were these plans to dilute the RTI law. So what happened is they started diluting the implementation. Now, by diluting the implementation, they, earlier, the implementation was very strict. So if anybody filed an RTI application, you would get the information within 30 days or 7 days, depending on whether your application was a normal application or an urgent application. But what they started doing is that they completely changed that, in the sense that they stopped providing information, especially project-related information, stopped being provided with that efficiency, and then you would have to go for the appeal process. Now, in the appeal process, many of the information officers or commissions were not appointed. And so there was nobody to go before an appeal. So your appeals would get delayed. Even the second appeal process would get delayed. So the entire process of obtaining information under RTI was frustrated, and the implementation or the strength or the teeth of that law itself was taken away. Now, what has happened is amendments were also brought in last year to the Data Protection Act. We were discussing the Data Protection Act earlier. There's also huge critical analysis of the Data Protection Act that came last year. And one of the biggest criticisms of the Act is that it actually amended it brought in amendments to the RTI law by weakening it, by diluting it. And so we were hoping for a stronger RTI law, because the 2005 RTI law, while it covers state, it does not cover private entities. It does not cover corporates. But who are the ones who are doing maximum projects today? They are the corporates. Even when the state does an infrastructure project, it gives the tenders to the corporates. So it's always a private interest which is involved. For instance, we say a highway is being done, an infrastructure project is being built for the people. It is being built by the state. It's not being built by the state. It is proposed by the state. Our money is put in that project. Public money is invested in the project. But who is the partner? Who is the implementation partner? Who is the design partner? A company like an L&T is the design partner. An implementation partner is like an Reliance or an Adani, who are doing the implementation. Look at metros everywhere. Look at airports everywhere. They're all being done by private entities. And some of the most richest corporates of India have, are involved in infrastructure. So infrastructure development has become one of the most important industries where our money goes. And these industries are all private industries. So, but we could not file an RTI in order to get any information from these industries which are doing the job of the state. Technically, they are taking our public money, but they are not able to file an RTI to them. So one of the things that people were hoping for was that RTI's ambit is increased so that we can also get information from corporates, so from private entities. But that was, instead of that happening, the amendments have now, in the name of privacy, shrunk our space. A lot of information that was available to us earlier is now not going to be made available to us because of the Data Protection Act. We also have, non-disclosure that has been taking place of vital information in project-related documents. So when you go to the Parivesh website and Environmental Clearance website are the websites where you get the, documents that are put out for the public on environment projects. Now, in the Parivesh website, there is an entire, for any project, you will find like an entire form, which will have different documents. For instance, it will have the application form, it will have the project report, it will have the feasibility studies, it will have all these things which will be there, depending on the stage, right? Now, in all of these, you will see, for instance, land documents are not put up. So people have to apply for these land documents for the local authorities, and they don't get these documents easily. Several critical documents which are important for us to assess the impact of the project are not put up. Cumulative studies are not conducted. What are the other projects that are going on in that area? We don't know anything about the company. What are the past violations? What are the other projects, incomplete projects? We don't have any kind of critical analysis of those companies. So there is a lot of information which ordinarily ought to be provided, which is not provided. And second type of information that you find over there is misinformation. Now there, when I mean misinformation is, let's say in a place, 1,000 trees are getting cut in order to facilitate an industry to put up their, put up their project. 1,000 trees are getting cut, but they will show that only 100 numbered trees are getting cut. The other trees which are not numbered are not going to be affected. So in this manner, misinformation takes place. And the people who come to survey, or people who come, in order to actually do site inspection when there is any kind of a dispute that is raised, okay, will only record that version. So how do people prove that an entire forest or an entire patch of trees, centuries old trees, which are all heritage trees, were destroyed by that company? It becomes my word against your word. So misinformation that happens over there, because these are all self-certified documents. A project report saying what is the impact that according to them, in the EIA process, okay, is a self-certified document. They'll put it up, and the government, does it check it? Does it verify it? These things become extremely important. The bureaucracy, to what extent it is in nexus of the corporate, again, these things become very important, and this furthers misrepresentation. Also, information is not available to communities in local language. So even if you get information under RTI, or even if you have these project documents put up over there, they don't provide the project documents in the local language of the affected community. Forget everything else. If you are doing a project in a forest where the local language is, let's say, Hindi, okay, then you can't just give an executive summary of the report. You should give every single document in Hindi, because the community that is getting affected only knows Hindi. But these things are not done. Okay, so these are the various ways in which we see the violation happening. You also see subverting of the public consultation and FPIC, which has happened. I did mention it earlier, so I'm not going to get into it in detail. But one of the biggest things that happens is that public hearings are misconducted. They are not conducted in a fair way. People are not allowed to speak. You have consent which is manufactured through threat, force, and fraud. Or now that we are seeing, consent is just not taken. Public consultation is just not conducted. Even when public objections are recorded in a public consultation process, they are completely disregarded. So it's just a mere formality. It's just about preparing a report, but in the end, you will pass the project without looking into any of the objections or suggestions of the public. Now, this is the entire environment impact assessment process. I'm mindful of the time, so I'm not going to get into this, but you will get this online. You also can go through the EIA notification of 2006, which provides for this. But this table is also available online, which will give you, the basic steps on how an EIA process takes place. Starting from the very first point of the project concept right up to the approval that is given to the project. Now, this is the 4-step process of the grant of EC, which is the EIA process. Now, what is happening right now? We have seen that we did have an EIA law which provided for this process, a 4-step process. Sorry, I'll just, just to give a context. First step is the screening of the application of the project or activity that, they plan to do, which is affecting the environment and which is covered under the EIA notification of 2006. EIA notification of 2006 has a schedule which covers certain high impact or polluting activities, for which environmental clearance is required to be done, and EIA is required to be done either, in 4 stages, 2 stages, or depending on what the impact of that project is. So your first step is the screening of applications. Second step is the scoping, in which the committee, which is the expert committee of the ministry, either at the state level or at the central level, it determines what are the terms of reference which they need to prepare in order to address all the environmental concerns for preparation of the EIA report. The EIA report, like I said, is prepared by the project proponent in order to respond to it, in order to ensure that their project does not affect, or they have enough mitigation studies and enough mitigation steps that they're taking to ensure that this will not impact the environment, or the environment will be compensated. Now, this EIA report, just on a side, these days is being prepared by project consultants, and they are now recognized under the law as well. So these environmental consultants which are there, they are the ones preparing it. It is not like the ministry actually puts in much effort into it. They literally become the people in between in order to ensure that the EC is granted. And that's also one of the reasons we are seeing today that whether it is forest clearance, CRZ clearance, or environmental clearance, there are handful projects where EC has been denied, where a clearance has been denied. Almost in all cases, the clearances are being granted. Imagine at a time of so much environmental destruction, we are looking at a huge grant of ECs, while 10 years back, if we look at the state, we could say so many ECs would get rejected because they did not meet the criteria. Then you have the third step, which is the public consultation process, which looks into the concerns of all the stakeholders, which are the affected persons, and those who are interested on environment as well as on the area. And you have appraisal, which is the detailed scrutiny by the expert appraisal committee. They scrutinize the entire report, they scrutinize the studies that have been done, they scrutinize the public consultation report, and they see, is this enough for us to grant environmental clearance? Have they taken care of all the things? Does this project actually, impact the environment? And if it does, they're supposed to reject the environmental clearance, right? So this is the stage at which the appraisal takes place. Of course, then the environmental clearance is allowed. Now we have what has happened to this notification now. This notification has been diluted by bringing in more than 150 amendments in the last decade. Now, the problem with the reason why this has happened is because the most important law on environment, which is the EIA notification of 2006, is not an act of the parliament. So there is no debate that takes place in the parliament in order to make any change in this. It is actually a notification. So this notification can just be amended by passing another notification. And most of the time, these amendment notifications are not even opened up to the public in order to give their objections or suggestions. In the name of public interest, that process is bypassed. And summarily, the amendment is passed. In this manner, some of the most vital provisions of the EIA notification have been diluted. And I won't get into the thing in a lot of detail. Of course, there is a lot written on it. I've also written some papers on it, which I can share. But this is a very important and critical point that we need to all address. Because if we want anything to happen, if we want things to change, we want to do any kind of climate action, we will have to look at how to strengthen the domestic regulation. And in that, EIA notification 2006 is going to be the most important one. An attempt was also made to completely overhaul and remove the EIA notification of 2006 and replace it with the draft EIA of 2020. This happened, in fact, during the pandemic. On 23rd March 2020, they came up with it. If you remember the partial lockdown or whatever happened on 22nd, Janta curfew, whatever happened on 22nd, and on 23rd, they brought this in where nobody was in a state to even respond to this. But this notification, a lot happened. People, there were petitions which were filed in court. There was an extension of time which was granted. Finally, it was, brought up till August 10th for public objections. 1.7 million, that is 17 lakh objections were received by the ministry against this. And even the UN special rapporteurs, addressed a communication to the Indian government on 31st of August 2020, questioning the draft EI notification of 2020. Now, so far it has not been passed, but it's not officially withdrawn. It may have lapsed, but this is the situation. Now, the next, again, Forest Conservation Act, there were a lot of amendments that were brought in, all to facilitate the diversion of forests. Land Acquisition Act, again, has seen many state amendments, which bypasses social impact assessment for linear infrastructure projects, which is chapter 2 of the land acquisition laws, and basically facilitates land acquisition without looking at the impact of the acquisition on the affected communities. You've similarly seen the coastal regulation zone of notification of 2019 that was brought in. Again, the CRZ notification of 2019, the CRZ notification of 2011 was again amended in the same fashion over a period of time. And then they brought in 2019, solidifying and increasing all those amendments to dilute the law. So this has also enabled the reclamation and commercial exploitation of coasts. It has in fact changed the coastline, the hazard line, the area which was available for development on the coast itself has been increased. And this is at a time when we are talking about the huge impact of sea level rise on Indian coasts. We've also seen the frequency and intensity of cyclones, and we've also seen how islands in India have been sinking because of the sea level rise, including an island in Lakshadweep which has sunk completely. So again, this law has been diluted. We've also seen the same thing in the mines and minerals law, where there was amendment brought in again during COVID to allow private auction of mines, and several other amendments that have been brought in, which have facilitated the increase in mining and extractive, in fact, coal mining and bauxite mining in many of the mineral-rich areas like Chhattisgarh, Odisha, and Jharkhand. And you also see that in these states, in order to execute these kinds of changes, they have put in military and paramilitary forces, which actually ensure that the local communities cannot raise their voice. And if they do, they are criminalized or they are, silenced. Then you have, again, Biodiversity Act and Aquaculture Act. Again, both of these acts were amended last year. I already spoke about the Biodiversity Act. The Aquaculture Act was also amended in order to allow for all these big, troll farming, the prawn farming that takes place, in order to facilitate that industry. These are some of the major dilutions that have happened. I don't think I'll have the time to get into them because I realize I had a 40-minute session. I'm already exceeding. But some of the amendments that were brought in, which were in favor of the, thermal, which basically will favor the thermal power sector, coal mining sector, a lot of the polluting sectors. In fact, a very big amendment that was brought in fact, exempted the linear infrastructure projects like highways and all of these various metros, all of these linear infrastructure projects that we are seeing are very big projects. They impact huge tracts of the environment, and they have been exempted from doing public consultation process. So people cannot complain about the environmental impact to the authorities because the public consultation process has been taken away altogether. Similarly, at a time when we needed to, earlier the environmental clearance was valid only for 5 years. At a time when construction speed has increased, technology has increased, everything, in terms of the efficiency of the construction industry has increased, and the environmental, impact, environmental destruction, climate change has also increased, because of which we need to make a stricter time. We need to ensure that, environmental impact assessment studies can have a minimum validity, because the environment is changing every year. So we would need to do a fresh impact assessment because the environment will change. The areas are developing every day. There are new projects coming up every day. So the impact is also increasing. At that time, from 5 years, it was increased to 7 years with a renewal of 3 years to make it 10 years. And now it has been increased to 11 years. So from 5 years, we are seeing an automated increase to 11 years with just a formality process of renewal. You also have post facto clearances which were brought in to completely do away with the concept of prior environmental clearance. When I mean prior environmental clearance, it means before you do any project or activity, before you commence any construction, you need to get an EC, which is an environmental clearance. But you take away that altogether by giving in a window to industries who did not take a prior environmental clearance and illegally set up an industry. So what should happen if somebody illegally does a construction? The government comes and demolishes it. So when industry comes and illegally sets up an industry without taking an environmental clearance, what should the government do? It should stop that industry, it should stop the activity. Instead, a regularization period was brought in by which post facto clearance was granted to regularize their operations by just taking a penalty. Now, this completely takes away the requirement of prior environmental clearance altogether. And in the draft EIA 2020 that was proposed, this was going to be brought in as a permanent provision. It would completely take away the whole purpose of the EIA notification of 2006. Similarly, the single window clearance process was brought in by bringing in Parivesh, which is the website I also said that you all should look at, by which you see if a project impacts both forests, both coasts, both forest coasts, and it has an environmental impact is covered by the EIA notification of 2006, or let's say it also impacts a wildlife or a protected area, a sanctuary, then in that case, you would need to go to each of these departments and fulfill the requirements, which made it cumbersome but extremely transparent as a process. Now, by bringing in the single window clearances, all of this is done through one portal, and it is done through one mechanism, one process. So many of the important steps, and especially where you need to look into the wildlife impact and forest impact before even looking into the other clearances, all of these were taken away because they also have FPIC, right? So some of these things were completely taken away. So again, this has led to a dilution. The entire EIA process and restrictions which were there under the CRZ notification, under the EIA process itself, the whole procedural restrictions that were provided, they themselves have been very severely diluted. For instance, if there were industries that were required to do a 4-step process, a rigorous process in order to take environmental clearance, they have been, exempted from that. They have been brought down a notch, and they have now, only to do a 2-step process. These are all categories of projects which are there over here, which will take time for me to explain, but in a way, they have diluted the process. If there were industries which, up to a particular threshold limit, which had to go and, take environmental clearance, let's say industries which, are up to, for instance, 50 metric tons, they need to go and, take environmental clearance under the EI notification of 2006. Their criteria, the threshold limits have been increased. So by increasing the threshold limits, those industries which earlier needed to take environmental clearance today don't need to take environmental clearance. So what was wrong earlier, has been made, legal now. What was illegal has been regularized. What was required to be restricted, the restriction has been removed. So all of these ways in which dilutions are. This I'm not going to get into. I did speak about some of these things, but there is a lot of writing on it. I also have a couple of materials. I have my own paper, which I can also circulate at the end of this. I think I have shared 2 of these papers as resource as well. So these give a lot more insight on both the draft EIA amendments as well as draft EIA 2020 notification, as well as the EIA notification 2006 amendments. Also, similarly, we've seen the Forest Conservation Act amendments that were brought in last year. They have eased diversion and exploitation of forests. They have attempted to, manufacture an increase in forest cover by bringing in all these artificial types of forests to be included as in the definition of forest. While actual forests which are there, if they are not notified, they are excluded from the protection under Forest Conservation Act. This is a very, very, very tricky way in which, or very mischievous way in which a lot of protected areas, which under the Godavaram judgment of 1996 of the Supreme Court, forest was looked at as the dictionary meaning of forest. So if there is a forest, if the state has failed to notify it, then why should that forest not get protection? That was the logic behind the court's judgment. But now, if the state has willfully ensured that they have not notified it because they want to give it to the corporates, or because they want to exploit it, or because they want to use it for industry, they are going to get a benefit from their own wrong. So those forests which are not notified of forests, but they are historically been forests and they are dense natural cover, they will not get protection under the Forest Conservation Act. And this will take away almost 90% of the forests of the Northeast, of Nagaland, for instance. More than 60% forests in Manipur will get affected. And we are seeing Manipur as a state is going through such huge ethnic conflict because of resource issues which are at the core of it. So land issues, territorial issues, forest issues, which are at the core of the conflict. So these, ways in which the protections are being removed, and like I said, forest diversion or deforestation. Deforestation, legal word is forest diversion under our laws, right? Forest diversion is one of the biggest reasons of carbon emissions. Forest diversion is just a nice way of saying that we are cutting the forest. So again, it is taking us miles away from our climate action goals. It also penalizes instead the local communities who actually protect the forest. The local communities are the ones who have been nurturing and guarding the forest. Every time anybody has come and tried to destroy it, whether it is a private entity, commercial entity, or a corporate entity, they are the ones who safeguard the forest. They are the ones who are being penalized for carrying out their traditional forestry activities, which are in sync with the forest and the environment, and they are indigenous. Again, it completely ignores the FRA, the Forest Rights Act, which gave the rights to the forest dwelling communities, and by that protected the rights of the forest. That law is being ignored. PESA is being ignored. Okay. Now, this is an era that we're looking at of deregulation. And that is to add to all of these laws that we have spoken about. We also have now these new corporate programs that are coming up. For instance, we have the Green Credit Program of 2023. I can share a latest representation from 2 months back that a lot of organizations together had sent out to the Ministry of Environment and Forest against the Green Credit Program that they released in October 2023. And they also came up with a notification under it in February, by which an attempt was made to incentivize forest diversion in the name that actual dense forest cover will be diverted and degraded forests will be used for afforestation to compensate for that diversion. Now, what are they calling as degraded forests? Shrublands, grasslands. They are all forests. They are a different type of forests. They are not degraded forests. They are extremely important separate carbon sinks and separate old forests. You cannot replace them. They also need to be intact, and this also needs to be intact. So what are you doing now? You're not only destroying the forest, you're also destroying the shrubland and putting in an artificial forest that may or may not survive. So all this Green Credit Program has been brought in, which is just bringing in this lopsided, unscientific proposal. Then you also have carbon credits that are being brought in. In the name of carbon credits, corporates can earn points, marketable credits, which they can trade in the global market. This is not even a regulated area. And it's a complete attempt at greenwashing. Like a corporate did something nice for the environment, so they will get certain credits, which they can monetize in order to destroy the environment. Again, an exercise of greenwashing. So these are some things that we have to be very watchful of when we look at policy, because this carbon credit is completely unregulated. In fact, right now, if we go to see, there is only one policy document which has come so far, which does not again provide for its modalities. It was also criticism that was of the Green Credit Program. Now the document which has come, again, it does not provide for the modalities and leaves a lot of discretion for exploitation. So these are some of the things that we will need to be very aware of when we look at environmental policy. Now, I'm not going to go into the rest of the slides, which are more about the different things that had happened. For instance, in 2020, some of the clearances, 31 clearances were granted in a day. All of these various things which show the mechanical manner in which huge tiger reserve sanctuaries, buffer zones were sought to be destroyed right during COVID. And that too by virtual hearing. 41 coal blocks were put up for option. The committee passed 30 projects in biodiverse area, which is the expert appraisal committee, for granting the environmental clearances under the EI notification of 2006. This is the manner in which public hearings have taken place. It's an example of the bullet train project, where local leaders itself were prohibited from attending and they were put in preventive detention. And cases were filed against them. So they were kept in the police station. So they could not go for the public consultation and give the objections of the community. Farmer leaders, local leaders, the leaders living in the community, they were prohibited from going in for the public consultation. This is of the 3 infrastructure projects in Goa. Again, in April 2020, during the peak of the lockdown, the components of these projects were passed through video conferencing. This entire area that you're seeing over here, a graveyard of forest, was destroyed without any cutting permissions during COVID. Again, because of the post facto clearance thing, taking benefit of it, LG Polymers had applied, it had irregularly, without any environmental clearance, started its work and started expansion of its chemical production of its polymers unit. And this unit did not have an environmental clearance between 1997 to 2019. Because of this window period that was brought in by an amendment notification in the EI notification of 2006, they got a chance to put an application for regularization. They continued, and then on the intervening night of May 6 and May 7, there was a huge toxic gas leak. These are the kind of things that can happen if no EC is taken. There are no safeguards in place. There are no ETPs that are put up. There are no precautions that are taken. And this led to 12 people dying who were working in the unit. So this is it. I'm going to end over here. I just wanted to end with some of the examples. There are many more, in fact, in the public domain. But I just wanted to leave you all with some thoughts. And I don't know how much time we have for the exchange, but I'm sorry for exceeding the time. Thank you.
Thank you, ma'am, for providing such a comprehensive and enlightening session. Now, we invite Professor Vibhuti Patel ji for her remarks. Ma'am, you are not audible.
Okay. Advocate Lara Jesani, you have made a very exhaustive presentation on how the forest laws have been diluted. I would like to know some of the success stories. Have people's movement resulted in stalling some of the hazardous and harmful projects? Number one. And currently, which are the areas in which a lot of mobilization at a grassroots level is happening?
So in terms of success, I think one of the biggest successes that we can look at is the draft EIA 2020. In the draft EIA 2020, because of the overwhelming public objections that came in, because a lot of youth organizations, all environmental organizations got together and they all sent out these mass public objections to the ministry. And also the issue got internationalized. It reached all the way up to the UN, which realized that while India is talking in many of the platforms globally on environment protection, it is bringing in a regressive law. I think it was a very important success story in my view, because it helped in halting the law. However, of course, the flip side is they continued to do what they were doing without the draft EIA 2020. They brought in all the amendments, and whatever was proposed under the draft EIA 2020 also, they have managed to successfully bring in by way of amendments in the EI notification of 2006. Some of the other success stories, I think, have happened where, communities have been united, and we have seen, major civil society opposition to projects. For instance, there have been, successful stories that we see, for instance, in Mitivedi in Gujarat, where again, the community got together and they opposed the nuclear power plant that was coming over there. And because of their relentless opposition, the government was forced to take back the project and change the site. Of course, which means that it will go to another site being a destructive project, and that community will now have to fight the battle. But it is a success story to some extent for at least the community that was fighting it there. There was a case also filed in court, but the case, the case did not even need to be pursued because the people's opposition itself, the civil society movement itself was so strong. We also saw momentary success in the RA movement when they had lost in the High Court, and the order of the court to go and cut the trees and allowing the government to go ahead. At that point of time, just because of the civil society effort, they managed to make the issue of saving RA forests a political issue, which became an important issue during the 2019 state elections in Maharashtra. And on the an important issue because of which also, along with some other issues, MBA won. And when MBA won, it stalled the project. But then later on, when the government was taken over by taking over Shiv Sena, and a lot of various changes happened, and the BJP and Shinde portion of Shiv Sena came into power in Maharashtra, they restored the project, and of course the car shed did happen. But these were momentary successes, but successes with the civil society were successful. Similarly, you also see some successes in court, but the successes are getting very, very rare. For instance, some of the most celebrated judgments that we see, have also actually been environmentally or for the project that was being challenged, very, very detrimental. You saw the Mopa Airport judgment, 2019. The most important principles on public consultation were upheld by Justice Chandrachud in the Mopa Airport judgment of 2019. But then again, that was reversed the following year, when Mopa Airport was allowed to happen, and now Mopa Airport has happened in Goa. So we've seen, such kind of Supreme Court, I feel, in the last few years especially, has not really, passed judgments where they have stopped destructive development. While they have laid down principles in some of the judgments, but actually stopping destructive development, actually, cancelling clearances, actually, cancelling those projects, that those kind of orders are not coming from the courts. High courts, we have seen some little amount of success, but in the biggest loss, I feel, has been the loss of the NGT. Between 2017 to 2020, the NGT was rendered ineffectual by bringing an amendment to the finance bill, because before 2017, NGT had been passing some of the most critical orders against the local authorities, the state, as well as the corporates for violating on environmental law. And in 2017, a finance bill amendment was brought in, which changed the appointment procedure, and then the vacancies were not filled. In fact, people had to approach the Supreme Court, and Supreme Court heard that matter, passed directions over a year. And finally, then the vacancies started being filled under that pressure. And even then, when it started being filled, it was very erratically filled. So while there would be a judicial member, there would be no expert member, and the matters would not be heard. Now, in the process of all of this, they have rendered the zonal benches of the NGT ineffectual. And we are not seeing that NGT return. And that's where, for those of us who do environmental practice, it's been a very, very big loss. Also, in those years of 3 or 4 years when, the NGT zonal benches were closed and the matters were happening through VC before the principal bench, litigations were not being filed. So environmental litigation has decreased massively because we have lost the forums to go and litigate. So, there have been a lot of challenges as well. While there are success stories, for instance, even the Vishwamitra Riverfront Development Project, where the NGT passed, an order of status quo prohibiting all constructions, and then also went on to hear the contempt of that order, which forced the government to withdraw. So those are one of the cases that I was doing. So similarly, we've seen also the Alembic chemicals, matter again, where, polluting industries were made to pay or stop their activities. So we have seen some prior to 2018, 2017, but after that, we have been facing a lot of challenge in trying to stop projects. But I think the answer today lies in, one, all of us being aware of the policy lacuna and now trying to drive for good policy, robust, strict policy, and policy that cannot be amended in this fashion, that is not so gullible, right? We need strong policy and definite policy by acts of the parliament. And second thing, which again is very important, is how do we strengthen ourselves as civil society? How do we create public awareness? How do we tell the citizens that this is your fight? And that is why every single environmental issue needs to be taken up by the civil society in a very big way.
Thank you.
Fellows can now ask their questions. Fellows can either raise their hand or type their queries in the question and answer box. We can see Nikhil ji is raising his hand. You may ask your question, Nikhil ji.
Am I audible now?
Yes.
Yes.
Good evening, Lara ma'am. It was indeed a very elaborate presentation, and I can resonate with your thoughts, whatever you have mentioned a lot, because what you said that how corporates need to implement those changes beforehand rather than doing a CSR later on and fixing the damages that they do. For example, the reforestation that they do without researching whether the damage that they have done, the industries have done while mining or doing other activities. They just blatantly plant any tree. For example, in Delhi, under the Harit Bharat Abhiyan, they are planting any trees and mostly trees, whereas grasslands need to be considered as well, where grasses need to be planted. So I totally resonate with your thoughts, and it was very good for me and validating for me to acknowledge that. Ma'am, when we talk about environmental justice, I wanted to understand why, of course, the issue of forest deforestation is a very prominent one in India. But we mostly, I guess you are one of the very few ones who have talked about the grasslands, but we usually skip the grasslands part and the ecosystem of the oceans, the seas and the oceans and the beach health. I remember coming across a post. There is a boy in Maharashtra. His name is Malhar Kalambe. As a Vibhuti ma'am also asked about a positive example that is going on, the positive change. So, and it is an example which falls under the civic movement, how people need to be civilized so that when the authorities take notice of those actions, they themselves are forced to implement those changes in the policy making system or in the laws. So that boy has cleansed the beaches and almost collected 100 million tons of waste from beaches in Maharashtra itself. So that is one very good and positive change that he has been doing. But often at many public forums, we often miss that topic while we talk about environmental justice. But I'm glad that you mentioned about grasslands. So that is a very good for, like, I really appreciated it. And but I wish to understand how the health of oceans and seas and beach health is being talked about in Indian scenario.
So when we talk about environmental justice, we talk about it in terms of the remedial system, and we talk about it in terms of the remedying violations. The nature conservation efforts, the cleaning efforts, all of these are the nature activities. Those things, or conservation efforts as we call them, they are part of environmentalism, and that is not necessarily what we talk of under the under the subject of environmental justice, because justice is when there is a wrong done, when there is a violation of the law that has been done, and there has to be a preventive, compensatory, remedial mechanism for that. So when we talk about justice, we will talk about who put the garbage over there. How can that person be punished? How can we stop more garbage from polluting the ocean? Not a citizen's effort to go and the garbage. So that is a difference between conservatism and environmental justice. That's the reason why we haven't spoken about the conservation efforts. Of course, there are a lot of conservation organizations that have been doing efforts at an individual level. There are also individuals who have been doing efforts. You have a lot of civil society efforts that take place. I was part of a nature club growing up in college, as well as as a student, as a school student. We were part of nature activities all the time because we were part of organizations that were doing that work. Even as a child, I used to be part of it. Now today, those who are going and standing up for environmental justice as children, they are saying that children are being employed by conservationists and activists in order to in order to exploit them in the name of conservation or in the name of the environment. But as children, we used to be part of those activities. We used to, in fact, even under Boy Scouts, and I don't know if you all had Girl Guides, we used to have all of that. But we would go around the entire ward of ours and go and, clean the wards. We used to pick up garbage. We used to, do desilting as part of our college club. We used to go to, streams which were full of silt. We used to go there inside those streams and do desilting exercises. Lot of river cleaning exercises, all ocean cleaning exercises, beach cleaning. All of these were part of were part of those exercises. So conservation activities have been there, but now today conservation activities are not going to help. We need to stop the wrong. We don't have any place to go and keep those 50 million tons of garbage. We don't have it, so we need to stop the garbage. That is where the issue of environmental justice comes in. But I'm very glad that you shared this. Of course, we all need to also do our own individual efforts in order to save the environment. So this is also important. But yeah, as policy activists, we will have to look at how to stop the wrongs as well.
Yes, sure, indeed, ma'am. Thank you so much.
We can see Shalvi Shahji is raising her hand. You may ask your question, Shalvi Shahji.
Thank you, Ritika. Hi, Lara, ma'am. How are you doing? Thank you for a wonderful session. It was just very, very, very insightful. I just had a quick question. So, when we also talk about, sanitary napkins and menstruation, so how do you think that we can also, spread awareness to the grassroots level specifically, where we can help in creating a behavioral shift key, how do you create that behavioral shift to use such products which are more sustainable rather than utilizing sanitary pads and disposing it on a larger basis, and reduce our carbon emissions?
So the thing is, I've been part of a lot of relief efforts as well. In my work as an activist with the organization, and
Correct.
otherwise as well. So one of the important things that I've noticed in all these years of doing relief and awareness work is that the maximum amount of the maximum amount of waste generation and the maximum amount of carbon emissions actually come from the upper middle class and the more affluent sections. And the elites are the ones who are actually generating waste the most, because most of the bastis, for instance, that I used to work in, they would not even use sanitary napkins. Most of them were using
cloths,
right?
Correct. Right.
Using sanitary napkins, and I can tell you this now, in today's day, all the middle class youth is using sanitary napkins.
Yes.
And talking about, a different income level people who are all using sanitary napkin. There are other things like menstrual cups that are being, that are being promoted. We have, sanitary panties which are washable, or we have, cloth pads which are, being promoted. But there are very few people who actually go for any of this.
True.
The whole consumeristic and aspirational class, the youth as well as the middle class, middle generation, are all blind to the impact of environment. But if you go to a basti and you talk to them about environment and you tell them, they will agree. But you go to a middle class society and tell them to give up their sanitary napkin, they will not agree.
They will not.
They will say
that is true.
Because the richer you are, the more you feel that you have an authority over resource.
Agreed.
Right? Yeah, and they will just come and say that, I can't use it because it is painful, because they'll come up with 10 excuses, right? And they're all individualistic. They are not looking at a community or a society level.
So, ma'am,
and you say that this waste is coming and it is polluting your, it is affecting your people. They of course will understand it, but so this is a huge problem. So I think important is how do we convert the people who have means to actually make these sustainable choices, because the people don't have means to make sustainable choices, and they are generating the least amount of waste. The maximum.
So, ma'am, how do you think that us who runs, I mean, I run a project for this. So how, and we actually go to busties, we go to the rural women out there, and what you are saying is absolutely correct, that they are the ones who are ready to shift. They understand the impact of this. So how do we become the catalyst of the change when it comes to the richer class of the people, or the target audience, which are the highest contributors towards not maintaining sustainability?
Because we have to have conversations with that class.
Right.
We don't need to go to the busties to improve.
Right.
We need to go to busties to help them. We don't need them to
yeah.
be making the environmental conservation efforts.
Correct.
Because
Right.
they're the ones who are actually doing the recycling. They are the ones who do not waste. They are the
Right.
ones who use the same bartan for centuries.
Centuries, correct.
Yeah, they use the same bartans that their mothers have given and their grandmothers have given. While it is our generation people, it is our class of people who actually go and buy new bartan from IKEA every day.
Yeah.
And they are, so the thing is that we don't need to go and convert them. They are not the audience. The audience has
Right.
people from the upper middle class, and they are the ones who we should be able to convert. So how do we create? I think social media is it has been impacted in some ways, but also how to start creating, more online meeting platforms, or even coming up with clubs. These were old ways of doing it. Have a, conversation club, dialogue club in affluent areas.
Right. Right.
Local hubs that are there, or the cafes that are there, or the
Correct.
who can give it, during a buzzing time, and
Yeah.
put out an invite over there, which is very woke, and people might just come. So I
Yeah.
think to change. The thing is that these kind of things will also need to be done with the right people who are actually generating this.
Correct. Correct. Got it. Thank you so much. Thank you.
Anyone else who want to put up their questions? Yeah. Gyaneshwari Pandey ji, you have just raised your hand. You may ask your question.
Yeah, am I audible?
Yeah, you are audible.
Yeah, okay, ma'am. So the session was like very detailed session, and you have talked about the Paris Agreement and the international scenario over the regulation of environmental degradation, deterioration. So I was intrigued to know, like human activity is of course a primary driver for climate change, but like due to advancing technology and advancement in weapons and ammunitions now, and nuclear weapons, and like gathering nuclear fuel, and the ongoing war situation, uh, even the space technology. I've read somewhere that there's a debris dumping in the outer space. So how situations like this is a very thoughtful issue, I would say. How this is to be regulated, and who is held responsible for such activities.
That is the whole thing. That's the whole thing. We have these empty regulations which are not binding. Now we have this entire war that is taking place, or rather this whole genocide that is taking place, in Palestine, where, huge amount of destruction has happened. And that is also environmentally extremely detrimental. No one can imagine the kind of destruction taking them back centuries that is, taking place in Palestine right now. And there is no account for the environmental destruction. Forget the fact that, of course, there is no account for the human life, property, destruction that is taking place over there. But at the same time, there is no account for the environmental destruction. Now, so many of these conventions and frameworks that are there, they should be getting activated, and they should be able to stop the use of, the arms and ammunition, the use of the bombs that are being used in order to destroy the environment, right? They are also being used in order to destroy that entire nation and its entire ecosystem. So there should be an binding effect of any of these laws. But the problem is that all of these instruments that are signed, internationally, and all of these conventions, they do not have a legally binding effect, and unless they translate into domestic legislation, the countries cannot be held accountable and against each other, even when forums that adjudicate on their disputes, like for instance, the ICJ was hearing the dispute filed by South Africa on the, on the destruction being caused by Israel and Palestine. And even though there were, orders passed by the ICJ on 3 occasions, ordering for a ceasefire and saying that, you have to stop it, you have to stop the war, even then these orders were not implemented. So the problem is the binding nature is not there, and hence these regulations don't have teeth. So we need two things, right? We need the law, but we also need the law or the order that is passed under it to be binding, to be implemented. And that part is missing as far as the international laws are concerned. So that is where we all are facing a huge challenge. And there has been a big call for more binding mechanisms and binding agreements, but you see all of these countries are also doing trade with each other. They are also benefiting from doing similar destructive activities in other areas. So they want to this intact. They do not want laws binding against them. That is the problem. There is no political will or intent.
Yeah. Thanks for addressing this one.
Yeah, anyone else would like to put up their question?
Thank you. Very critical questions have come though. Very, very good questions.
So I think we should move forward. Okay. Thank you, ma'am.
Thank you.
We at IMPRI hope you continue to collaborate with us in the future as well. Moving on to our next session, I am honored to invite Advocate Dr. Shalu Nigamji for a legal hands-on session. The floor is all yours, ma'am.
Thank you very much. It's a great, we have two very great sessions today. But I will be talking about a completely different kind of thing. And, we are just shifting from here to a completely different topic where I'll be talking about capital punishment or death penalty and how it is, going about in India. So if we talk about, India is, in favor of, giving death penalties, and these are the sections under the Indian Penal Code where, death penalties being given for various, the crimes the person is committing. So if you're committing murder, if you're committing treason, if you're committing some kind of mutiny against the government, if you are kidnapping for ransom, if there is a rape of child below 12 years of age, there is gang rape. So in all those cases, the courts can give you death penalty. So, and if you talk about the non-Indian Penal Code offenses, so there are certain other acts such as Army Act, Assam Rifle Act, the Narcotic Drugs and Psychotropic Substance Act, the Border Security Force Act, the Organized Crime Act in Maharashtra and Karnataka, under which death penalty could be given for various offenses. Now, if you talk about this century, since 2000, India has, carried out execution in eight persons have been executed over different, period of time. So in 2004, we have seen death penalty being given to a person called Dhananjay Chatterjee, and because of the charges under rape. Then Ajmal Kasab, Afzal Guru, we all know these cases, and of course the Nirbhaya rape case. We know how those 4 people were hanged. So if we talk about the legal aspect, we have seen the Supreme Court judgments in Bachan Singh case in 1980. Supreme Court has evolved the principle of rarest of rare case. That means India has not abolished death penalty, but the Supreme Court says that in rarest of rare cases, the death penalty could be given. Though there are certain judges which says that because the death penalty is discriminatory, it's against the poor people, so it should be completely avoided. They say it's a violation of Article 21 of the Constitution, that is a right to life. So how can the state take away the right to life of a person when the state is promising the right to life and dignity? So, these are the arguments which are being given. In another case in 1983, the court has laid down 5 categories, in which, according to which the court will decide whether the person should be given a death penalty or not. So it could be manner of commission of murder, the motive of the crime, the nature of the crime, the magnitude of the crime, and the personality of the victim. And this is the data, number of people who are on death row each year. So in 2016, we have 400 people, and in 2023, this number has increased to 561. So 561 people are, they have been waiting for death penalty by the end of 2023. So in this past 2 decades, we have seen the rise of 45.7% of such inmates who are waiting in the prisons for their death penalty to be executed. If you talk about the cases which are pending in the courts, so 488 death prisoners currently they are facing, they are awaiting judgment. This is the report by Project 39A. You can go to the internet, you can search for this, and they have the whole reports, and these reports are coming since 2016, annual reports they're giving, and they're talking about number of people who are being, being hanged every year, and, the kind of, it's a whole report, so you can go through that. So, if we talk about the trial courts, and now the trial courts till now, they have given 120 death sentences in 2023, and this is nearly 53.3%. High courts, the process is that once the trial court gives the death penalty, that has to be confirmed by the High Court. Now, in 36 of such cases, the prisoners are discharged, and the High Court has asked the trial court that that there is a lapse in in different kind of things, that the cross-examination is not being conducted properly, the forensic evidences were not properly examined, so they have asked trial courts to re-examine those cases. Now, if we talk about recent development, Supreme Court has said that if to examine the hanging as a method, should it be because 40 years back we have a judgment by the High Court which says that all the prisoners who should be executed by hanging. Now there could be other methods of killing people, because in some places they are just giving poisons. They're also talking about killing with guns. So you have different methods. But Supreme Court is now saying that should we examine that hanging as a method is in line with the constitutional practices. Now we have also seen that since yesterday, this new criminal law, this entire bunch is coming, Patel and all those IPC, CRPC, and all those laws are being amended. So as per this amended laws, now the number of offenses which are being punishable by deaths, earlier it was in IPC, there were 12 kind of offenses in which the courts could give you death penalty, but now they have expanded to 18. So India, what is doing is that, as just reading that even in the cases of sexual offense, they are talking about, that person should be penalized with death sentence. So now I am asking your views. What do you want? How do you see that? This whole idea, because a lot of debates have been happening since, in Afzal Guru case, in different cases, we have seen that the people have a lot of emotions in the Nirbhaya protest. People were demanding that these people should be hanged, they should be what are your views? I just want to know, there is no correct or incorrect kind of a thing. You can just share your views. So I'll just maybe, stop here and then we can continue. So anybody who would like to share their view?
Hello, ma'am. Am I audible?
Yes.
Yeah.
So, ma'am, I am like totally against capital punishment and especially the penalty because, as we all know, the judgment is given by persons who are judges. So there is always a possibility of human error in every judgment. It's not free from all biases, if you think so. So there's a particular sanctity attached to life. It's not like any other punishment given, especially death penalty. So like for me, I'm totally against death penalty.
Thank you so much. Anyone else?
Anyone else who would like to give their views on capital punishment?
Deepika, what is your view? You also share?
I'm not against capital punishment because in our country, most of the time justice is delayed. So I think in most of the cases like rape cases and all, capital punishment should be given.
Thank you.
This is my view.
Thank you so much. Anyone else?
Ma'am, there is also one observation which I would like to share. I was reading an article on like death penalty many years ago, which says like, as you said, that death penalty should be awarded in only the rarest of the rare cases. So, and in rarest of, which means that there are two type of circumstances or factors which needs to be taken into account. One is like aggravating circumstances and other is mitigating circumstances. So what the author of the article, what he was trying to say, that most lawyers try to, even judges try to balance the mitigating circumstances versus aggravating circumstances, which to the author, he says that this approach is like really wrong because how the human psychology works, the aggravating circumstances naturally takes like more, it's going to outweigh the mitigating circumstances. So the approach should be that even if there is one single mitigating circumstance, the death penalty shouldn't be awarded. So this is
For the people who may not understand the legal complexity, please explain what is aggravating circumstances and what is mitigating circumstances.
so aggravating circumstances, any case is like which which makes the crime, which aggravates. I can't explain this. Give me
No,
one
but there
second.
see, I am opposed to capital punishment, but at the same time, these aggravating circumstances and mitigating circumstances
Like
is full of biases. If a
it's full
husband
of
beats his wife, I was in Los Angeles, where the Los Angeles Bar Association declared a Japanese man had killed his wife.
Yeah.
And then the bar council, they said, but it is allowed in Japan because in Japanese society, any wife who is not loyal to her husband husband would kill her. No, so because she created that aggravating circumstances by falling in love, whatever, he was a suspect. He suspected that she was not there. See,
Yes,
in
ma'am.
every case of domestic violence, when you go, the police,
Yeah.
that in-laws,
Exactly, ma'am.
relatives, neighbor, they all say she deserved it because she aggravated. She argued out. She back answered. So she created aggravation, no? Or when the relatives came, she did not serve tea or she did not look after her in-laws so well. So this is, and even if you read NFHS report, popular understanding of aggravating circumstances is completely different from the existing power relationship and the social surrounding in which the human interactions take place, no? So it would be really misleading. I don't support capital punishment. I just want to say,
Exactly,
but at
ma'am.
the same time, this
That's
thing
what I
about
said, that humans are like full of like judgments are given by judges who are humans, so there is a possibility of error on every occasion. So
But there have been
the,
judgments in Allahabad court. There have been judgments in where the husband was granted divorce because she created aggravating circumstances by not bringing snacks and tea as soon as his friends came in and this thing. There was a case in Punjab High Court where the court gave a restitution of conjugal right to a husband because wife was got promotion. She became a headmistress.
yes,
She
ma'am.
said, yeah, and she said that for 5 days she will be in the new place because she was transferred also, and Saturday, Sunday she will be with this thing. The court said that it is a duty of a wife to look after the family, and
Yes,
she
ma'am.
is
They are
creating disturbance.
very regressive judgments, because judges are at the
Yeah.
end of the day they
Because,
are like a product of the society.
yeah,
So
so the victim will always be said that you have aggravated the situation, because that's what parents also
no,
say
but
when they
what
beat up their child, no, that child was mischievous, so we beat
like
them up.
yeah, ma'am. But in the case of death penalty, like this, in particularly in the cases of death penalty, it has to be given in rarest of the rare cases, which means that the crime which the culprit has committed, it is so intense that no, nothing else should be awarded. There is no another punishment which matlab it is which commensurates with the kind of crime which he has done.
But
So
actually, historical experience shows that life imprisonment is far more painful, and that's why you see so many
yes,
of the prison. Recently, the whole case of the person who committed suicide who was involved in the high-profile trafficking issue. No, he committed suicide in jail. It was so painful for him. It was so daily humiliation, daily torture, daily this thing. That is a far more painful than just killing a person and just
yes,
freeing
ma'am.
him from what's because
Totally.
that's what we have heard from the prison who have been there, no, lifelong in prison. That is really painful.
Yes, ma'am.
But otherwise, see, for me, I don't see it from the point of view of criminal, one who commits the crime. Point of view of the society which internalizes that you can take, state can take life, no? That itself is extremely scary. That idea itself
Totally.
is very scary. That state can do, because state individual committing crime, yes, that is there, and the law enforcement machinery has to be there. But state taking human life, because state's role is that of looking after the community. And when state takes the role of a killer, no, by institutionalizing capital punishment, that is a very scary situation. And actual experiences of South Africa, several countries have shown it is basically the innocent poor who don't have anyone to defend them. They are the ones who get killed under capital punishment, not the actual criminal, no one who has committed that crime. So that also happens in a very big way. Another thing is that if you keep this kind of a capital punishment after Nirbhaya tragedy, you must have noticed most of the cases of gang rape are happening with extremely young girls, 11-year-old, 12-year-old, 13-year-old. No, these are the girls. And after rape, earlier they would leave that person alive. Now they are killing them just to kill the evidence. So that is not only in India. In several countries, it is found that to destroy the evidence, they would kill the survivor or a rape victim. Earlier, it was not happening, but it is only fear of capital punishment which makes them do. So there are many ramifications to this painful.
Yes, ma'am.
application.
Like law alone as an instrument can't address like the social structural inequalities that have
Correct.
existed
Yeah.
for
Yeah,
so long.
and social
They have
structures also.
seeped in they have seeped into the society by centuries of practices. So just by passing one law, you can't address, as you have mentioned, the case of restitution of conjugal rights. So
Yeah.
it shows
And
that how society works, and how like law, even though like RCR, it is couched in gender neutral terms. It gives equal rights to both wife and husband to get the custody, to to enjoy the company of the spouse. But the reality, the cases show that it has always been used against women, and especially one who have gotten employment, who have gained who are gainfully employed outside the city or outside the way the husband lives. So there is a whole concept of matrimonial home, why only husband's house should be considered as the matrimonial house. So that's there.
And I think even at a ground level, a lot of things happen. Like you saw in Nagpur, Akku Yadav, who used to pick up women and rape them. It was women from the community, they killed him, no? And in the
Yes.
court, when they say who is the murderer, some 400 women got up and they said, we are the murderers. Court could not do anything. There was just no evidence. These things are also happening. That is also
Yes.
very, the ground level justice mechanisms, they can also be extremely brutal. But women were just fed up because it happened with so many women. Almost every woman in the Basti had been raped. And at any woman, no, they would just pick up a middle-aged woman, young woman, girl, anybody.
Yes.
That was the kind of terror he had created. Then women got fed up. They said, do or die spirit, no? And they just killed them.
Even this
Police did
Madonna
not
rape case, if you
Yeah.
remember that Madonna rape case, the women,
Correct.
the mothers who came
Yeah.
out and
Manipur,
they
yeah.
paraded, please,
Yeah.
Indian Army will rape us. So, that kind of things are also happening. So,
Yeah.
coming back to capital punishment. So more nations have abolished capital punishment. If you talk about Europe and other countries, many countries have abolished capital punishment. If you talk about Amnesty International, as per their report, they say that 18 countries have performed execution in 2020, and during 2022, around 831 executions have been committed in 16 countries. So, for example, Iran has hanged 596 people. Saudi Arabia has, and Iran has also executed 15 women. Saudi Arabia has executed 145 men and 1 woman. Kuwait has hanged 2 women for murder. Bangladesh has hanged 4 men, and even USA, it's supposed to be. It says that human rights are kind of a specialty, and they have executed 18 men. Singapore, they have executed 11 people for drug trafficking. So women account for less than 1% of execution. This is what the report says. And so the countries who have retained the death penalty are United States, Japan, Taiwan, Singapore, South Korea, and including China, India, and Middle East countries. Though American courts, they and even the Indian courts, in some cases, they have said that capital punishment is barbaric and excessive, but the state is retaining that kind of provision. UN Commission on Human Rights, they have time to time they have adopted resolutions. The first such resolution was adopted in 2007, and it calls upon the states who retain death penalty to progressively restrict the use of death penalty and number of offenses for which it may be imposed. But again, right now with new criminal laws, we are expanding it. So we are going in opposite direction. But so the advocate for the death penalty, why they say that it deters crime. It is a good tool for police and prosecutors in plea bargaining. It makes sure that convicted criminals do not offend again. It gives an example to the other criminals in the society. So these kind of arguments which are being given, and it says that for heinous crimes such as murder, terrorism, war crimes, and military justice, they should go for a death penalty. And even some of the, if you read the old scholars, those philosophers like, the Kant, John Stuart Mill, they also have said that, death penalty should be given. And, so you can just go and read it. So there's, this whole debate is going on for centuries. This debate is going on. But how those who favor abolition of death penalty, they say that retribution is a simple revenge and it cannot be condoned. In modern times, it is considered as a primitive kind of justice. So it is basically a state-sanctioned practice of killing people, and they believe that capital punishment is a worst violation of human rights. It is irreversible. Once a person is hanged, you can't bring that life back. if you realize that, and in some cases it has happened that, after the person is being hanged and it was realized that, no, he has not committed the crime. So, those kind of things have also happened. So basically, it is argued that it may lead to miscarriage of justice, and there could be unfair execution, as we have discussed. And Amnesty International, it says that death penalty breaches the right to life, right to live free from torture or cruel, inhuman, or degrading treatment or punishment. So in India, again, we have to see that, how if this new criminal laws are being brought, and if the state is talking about, strengthening this kind of punishment, so will it reduce the rate of crime against women? Because they are saying that in rape cases, in sexual offense cases against women, we are making the tough laws. Now, in the name of tough laws, if you're giving death penalty, if you're giving serious penalties, will it reduce the crime? So the National Crime Record Bureau report shows that around 129 people have been awarded a death sentence, but again, the crime against women have not been reduced. So generally, in some cases, it has also come out that death penalty is being given because of anxiety and anger among the crowd. Because if you see the Dhananjay Chatterjee's case in 2014, after, because there was much outrage and the court in its judgment, it says that because we have to think about the conscience of the conscience of this community, and therefore we have to harm this person. So the laws are weaponized against the weaker section. That is also happening. So if you analyze the judgments in the rarest of rare cases, again, as we have discussed, that there is no consensus among judges. So it has happened that trial court has given death penalty, but which was refused by High Court, or even if trial court and high courts have said that, okay, death penalty should be given, but Supreme Court says that no, it shouldn't be given. So these kind of things are happening. So we have to really collate this kind of data, in how many of such cases these things have happened. So I think we need to do more research on this issue. But between 2000 and 2015, the death penalties awarded by the trial court, some of them have ended up in acquittal. And also, the procedure is that any person who has been given death penalty, and this has been confirmed by the Supreme Court, that then the person can go to the for the mercy petition, or you can go to the president. And sometimes presidents, again, the subjectivity comes in, and they say that, okay, isko milna chahiye, isko nahi milna chahiye. So those principles, the kind of way the decisions have been taken, those are different, and what kind of principles are being followed, those are not clear. This is again the data which is being, the study which is being conducted by Project 39A. It says that if you do the research of the prisoners who have been sentenced to death, you will find that most of them, 74% of them, are from economic vulnerable kind of situations in terms of their occupation and land holding. They are vulnerable, and these kind of people are awarded death penalty. So is the problem is with the system, or is the problem the kind of trial? Because if you see even the social profile, now 76% of prisoners who have been sentenced to death in India, they are from backward classes or from religious minorities. So again, the educational profile, if you see, 62% of the prisoners who have been sentenced to death, they have not even completed their secondary education. So in terms of legal rights, if we see right to fair trial, so that is, sometimes the legal aid is not available. And if you see Justice Lalit's lecture in 2023, he's the former Chief Justice of India, and he says that what I found is that in 75% of cases where people are from below poverty line, and they definitely require legal aid. But the legal aid is not, being made available to them. So it's only made available only to 12% of people. So 12 to 75% of people who are facing criminal prosecution, they don't even have legal aid. So in that case, how can you expect a person to really, file a case and to fight conviction? So also there are within the courts, there are problems that the voices of victims and witnesses, they are being silenced because the accused person are more powerful, and we see that the kind of power dynamics that operate within the courtroom, in terms of, as ma'am has said, that there are cases, how women are being treated, women victims are treated, and how the powerful men, as rapists or as husbands who are beating women, so there's a whole dynamic or power dynamic which operates within the courtroom. So we have to consider that. Now, so the judges again, we have the courts where most of the judges are men, or they are there with this patriarchal thinking, and they sympathize with the culprits and acquit them on the flimsy ground. So there are judgments after judgments. In my own study on domestic violence and dowry violence, we have seen, that the culprit, the man has family to look after, तो इसलिए इसको acquit कर दो. So those kind of judgments are there, and the way the courts operate. The powerful men, they deploy all their resources, connection, and their position to influence investigation. So there are various movies you can go to this Netflix. It is also showing the movie called Court, and that is also available on the YouTube. So you can see in that movie how the court dynamics operate and how poor people are being denied justice. So what do we need? We need better training for effective investigation. We need to talk about rights of victims, and we have to talk about more courts and fast track justice. We have already discussed that. So retribution is something which is, which could be there, which can satisfy the anger of the society. But we have to talk about restorative and rehabilitative justice. There is a PUCL report in 2008, and it analyzed the judgment for the period over 50 years, from 1950 to 2006, in which death penalties were given. So there were 700 Supreme Court judgments they have analyzed, and they say that death penalty works under the fear, that there are various flaws and it should be abolished. The report says that Indian judicial system has failed to meet its uniform standards, and the golden rule of rarest of rare case is not being adhered to. And there are various administrative flaws, such as consideration of evidence, inadequate legal representation. There is arbitrary sentencing. So all those kind of things they have said in their report. This report is again available on the internet. You can go and read it. Justice Verma Committee, which was formed after the Nirbhaya case, it also says that death penalty shouldn't be given. It is not a solution. And what they said is that in cases of the rapes and the extreme kind of cases where violence have taken place, so the person could be held behind the prison for for life term. Earlier it was 14 years, then they increased it to 20 years, and now they also said that you can, for the life term, the person can be held behind the bars instead of taking his life and talking about death penalty. There are several reports by the law commissions which says that death penalty does not serve any purpose. So the courts are granting life imprisonment. So what we need is victim or survivor-centric justice system rather than talking about strong laws. We need to talk about rehabilitation and safety plans for victims of violence. We have to talk about eliminating the culture of rape or the culture of violence, and those who commit crime, they should be penalized. Right now, the thing is, which is happening as rape, we have seen that even that case where the Porsche car has killed people on the pavement, And later they say that the driver, the owner was not driving the car. The driver who was driving the car. And we have seen many cases where the rich people have, elite people, they have given these kind of things. Poor people are being, held accountable. So fixing the accountability of the culprit is important. So we have to talk about certainty of punishment, and we have to talk about efficiency of justice system. We have to talk about, proper witness and victim protection program. So we need to make fundamental structural changes to eliminate the culture of violence. And this is just the quote from former UN General Secretary General, and he says that right to life is the foundation of all human rights. Taking of life is irreversible and goes against our fundamental beliefs in dignity and worth of every human being. So I called upon all the world leaders, legislators, and officials to stop execution. And there is no place of death penalty in 21st century. So I'll stop here, and we can have more discussions on this issue. Thank you.
Thank you, ma'am. Now we would like to invite Professor Vibhuti Patel ji for her remarks on the session.
Yeah.
Over to you, ma'am.
I think this is a very important topic we have taken up. World community is discussing it. And if we call ourselves civilized, and especially the state which talks about human rights, how can it take away the life? So I think that is also globally being discussed. And I think evidences have shown that this kind of barbaric treatment by the state, institutionalizing, taking away of a life of a person, is not justifiable. And that's why we see that increasing number of states have abandoned, nation states have abandoned capital punishment. But still, I think the debate must be on, and we must discuss. And as Dr. Shalu Nigam told us, that the way 39A project has been bringing out more evidences from the grassroots level. And currently what we are seeing, that if the rulers have a different ideology, there's so many women who have been killed because if they don't believe in right to abortion. So many dictators have killed women who have used medical abortion. No? So they have also been killed. That used to it used to happen in several Latin American countries. Or this whole question of Islamic punishment, that if your scarf just moves and your hair is seen, then you are also considered to be a criminal. And we saw how in Iran, young woman was like, I think they say it's death by negligence. But so rulers can also have a very, very regressive ideology, and they can use this kind of weapon to kill anybody who doesn't agree with them or who have a very different kind of lifestyle. So I think under no circumstances we should allow a state to resort to taking away human life. Thank you. Thank you. Very strong presentation, evidence-based, data-driven presentation. Dr. Shalu.
Thank you. Any questions anyone have, or just want to share something? Your thoughts or ideas or anything?
Fellows can raise their hand or type their question in the chat box. Okay. Anyone who would like to ask some questions? I think we should move forward, ma'am.
Yeah.
Thank you, ma'am. It's always a pleasure to be learning from you. As we come to the end of day 4 of LPPYF Law and Public Policy Youth Fellowship Cohort 3.0 Summer 2024 Advancing Justice, Bridging Gaps in Public Policy Enforcement, an online national summer school program, a 1-month immersive online law and public policy awareness certificate training course and internship program. I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our experts for the day 4 session, Mr. Himanshu Shekhar ji, Advocate Lara Jesani ji, and Advocate Dr. Shalu Nigam ji for taking out their valuable time and allowing us to learn from this online certificate program. We thank our chief, Professor Vibhuti Patel ji, for convening all the sessions. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you next Tuesday on July 9th for our day 5 of this certification course. We are grateful if you are watching us later on YouTube or listening to us on various podcasts or reading our publications. We hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good day. Thank you.
Thank you, Ritika, conducting the session so well.